yeah. One more time around. Everything's slowing down, can't control it. Say that you're for me. Right now I need loyalty. It's hard for me to trust you. I've been here before this. I've been through the troubles. It's hard to let you in. I've been giving you the runaround. I double on the dosage. I don't need emotion, no. Right now we young and we dumb and we lit. Been thinking back before when we was kids, yeah. I was caught up in the mystery, yeah. And we live for the moment, respond to a calling. It's bigger than all of us, right to the wheels. Give anything to feel something real. High if I fall, no I did it going all in. At the time of my life, right for squad. Look the lights through the fog, but we made it, yeah. I'll be good by the morning. I feel like I'm falling. It feel like I'm falling. It feel like I'm falling. It feel like I'm falling. Real eyes see real eyes, real shit, real life, real rare. I'm on edge, I make noise, they all is. No cap, all facts, eyes low, but I'm still woke. No patience, heart glacier, can't see me, I'm the young ghost. Phone blaring, overbearing, shit a blessing that I overcherish. Got these rap niggas' eyes open glaring, cause they overjealous, I'm so overzealous. Whiskey side with the rosemary, and used to want it, not a whole staring. That was back before I could afford to care. Now we on course to take the tour to Paris. I blew up the bag, that hit me as bad. The guy from the racks that they chastised, they could fast die, telling mad lies. Going bad, tell them get they act right. On my last light, I poured a potion, I've been out of orbit. I've been moving slowly, got me going up, they got my head clouded. I'll be good by the morning. At the time of my life, right for the squad. Look, lights through the fog, but we made it, yeah.
What up, you guys? Today I want to react to the closing arguments. This is what you guys we've been wanting. We've been waiting for this. We want to know what the jury is going to do with Kyle Rittenhouse. How are they going to pretty much judge this guy? I don't know. This has been a very stressful, for me at least. This whole situation, this whole court case has been stressful to watch because you just don't know what's going on. I mean, the judge is so iffy. He's so wishy-washy. And I just don't know. He seems biased to me. So I feel like, he's just leaning towards the side of Kyle Rittenhouse. And today's the day, you guys. We are going to find out. Let me know in the comment section, you guys, what your thoughts are and what you guys are feeling as far as this case. I want to basically get everybody's opinion on what you think is going on with this case. What's your thoughts? Do you think that he will get the life sentence, because that is the harshest sentence he could get if he's charged with the first-degree murder? Or do you think that he's going to get the lesser charge? Because, on Friday, they were going through all the other lesser charges that he could get. So this is quite interesting, you guys, to see how this is going to play out. I want you guys to interact, and later on, I want to do some call-ins. Maybe you guys can call in, maybe when there's a recess or a break. Let me see if the trial's on yet. Give me a second here to see what's going on. Okay, what's up, Ruben? How you doing? Ruben said the judge will declare a mistrial with prejudice. Wow. Is that what you're thinking? Why is that, Ruben? I know the judge brought it up. I know that, he was snapping on the prosecutor. He didn't like the fact that Binger was bringing up some stuff that I guess he wasn't supposed to bring up. And he had threatened to do that, to do a mistrial. I really don't think he will, though. I don't think so. I will be very surprised if he did that. Leo, what's up? How you doing? Thanks for joining the stream. You guys, if the trial, I'm looking for the trial right now. What time is it? 9:01. It should be on. So if you guys find the trial on a certain network, let me know, because I'm looking for it right now. And let me know what city and state are you guys watching from? What platform are you coming from? Let me know if you're on YouTube, Twitch, LinkedIn, Twitter. Let me know. Leo, Kevin is doing his own stream. He's streaming from his place. So he's not joining us today. Let's see. I guess it just hasn't started yet, you guys. Let me see here. So you guys, they have National Guard is on standby. And they have 500 troops on standby with the National Guard. I guess for the verdict, getting ready for that. Okay, I think I found something here. Let me see if I could get in there. Okay. All right, you guys. I believe this is the trial. I guess they haven't came in quite yet.
What's up, you guys? I'm in Kenosha after the Jacob Blake verdict.
Let me see.
The officer will not be charged. People are agitated. We got marches going on and arrests going on right now.
Okay, so they must be on some kind of recess. Who else we got here? Who was that? Jessica? He's streaming on his YouTube channel. Okay, you're talking about Kevin. How you doing? What's going on with you? Leo's watching from Norway. What's up? What's up? I'm getting some strange feedback from another. Let me see what's going on here. Bear with me, guys. I'm trying to figure this out. Okay. Let's see.
I'm gonna call you back because I'm excusing.
This is so weird. I'm getting some weird sounds
What's up, you
here.
guys? I'm in Kenosha after the Jacob.
Okay, I think I figured that out. Let's see. Ruben, you got an interesting comment here. There are no fences installed around the courthouse. Yeah, I noticed that too. I'm surprised they didn't put the fences up yet. I wonder if they're gonna put the fences up. Um, I know last around the Jacob Blake, when that answer was coming out as far as if that cop was going to be charged, they already had the fences up and everything. So I am quite surprised that they don't have the fences up right now. So I don't know. Maybe they don't expect anything to pop off all too much, and they're just on standby and they're not really posted up yet. That could be the case. Let's see. If you guys see it, if you guys see anything else going on with the court case on another network, if they're starting or something, let me know, because I'm looking at different channels here to see what's going on in the court. Just make sure I'm not missing anything here. As far as this one looks like they are in some kind of recess mode or something, I guess. Okay, let's see. Just bear with me, you guys. I'm almost done. I'm just trying to make sure everything is all good on all my different channels here. Hooray! What's up, Leo? Thanks for sharing that stream out. Appreciate that. Let's see here. Okay. So here's a comment. So you want Kyle's verdict to be not guilty. Alrighty. And you're on YouTube. You want the not guilty plea. What are you guys, who else is wanting a not guilty? I want to hear from all sides. I want to hear what everybody has to say about this. I mean, and we got a little time because they haven't started yet in court. From what I'm seeing, I'm watching my screen. I don't see that they have started yet. So we got a little time, you guys, to do some discussing here. If you guys think he should, if you want a not guilty plea, tell me why you feel like he's not guilty. And if you do want a guilty plea, let me know why you want him guilty. I mean, let's have a conversation, you guys. We got time. Also, let me know before I get started, how's the audio? How's the video looking on your end? Is the audio right? Is it a little janky? Let me know now so I don't get too caught up. What we got here? Whoa, Leo got a whole book right here. Let's see if I can fit that in there. So, Leo on Facebook. Let me read this. Your justice system is dysfunctional if this guy don't get murdered. A short story. One night I was sitting in my car on a parking lot, waiting for my girlfriend. Two unknown white men out of the blue jumped in my and started. Jumped in your car? Jumped in my car, I'm assuming, and started to threaten me in my life. Told me to get out of my car so that they could beat me up. Well, F me up. I told them to go away and leave me alone over and over. They put hands on me and punched me in the chest. I had to defend myself and knocked out both of them. They then went to the police and said that I attacked them. What? Okay, that sounds real crazy. So you said you're, Leo, you said you're in Norway? Because that don't sound like something that would happen here in the States. What's up? What's up? How you doing? Rhinehouse, Mon. How you doing, man? Long time no see. Thanks for joining the stream. Okay, you guys. So they might be starting any minute now. Hey, I didn't notice that was Jesse Jackson right there. So Jesse Jackson is in Kenosha, you guys. That's him. That's him right there, Jesse Jackson. I had no idea he would be in court today, but he is definitely in the courthouse. That's Jesse Jackson. Who we got here? Rubly. Sorry if you guys came to this channel to get names pronounced right. I'm going to tell you right now, you are definitely not on the right stream. I'm going to butcher everybody's name, so bear with me. I suck at it. But I think your name is Rumpley. You said that is clear evidence from Leo that Rittenhouse is guilty. Okay. So I appreciate you guys being patient and as we wait for this thing to start as far as this court thing. I wonder who else is in the house. I know Jesse Jackson's there. I wonder who else might be in the courtroom that they're not showing. Ruben is saying cover the nose. Yeah, that's the way to wear it, man. You pull that baby down. That way you can eat, you can drink your coffee. Speaking of coffee, I gotta have my coffee, you guys. You guys, let me know if you got your coffee this morning. I'm a coffee person. I cannot function without coffee. I've been up all night, literally all night. I've been up, and I gotta have my coffee. Let me know if you guys had your coffee yet. It looks like the court video just went black, so that's not on my end, just so you guys know. Let me see something here. All right, let's come back. Let's come back to the courthouse, you guys. Let me switch the scene around a little bit. All right, that way we can have a little discussion. What is this coming from? Let's see if I can. I don't like how that looks on the. Okay. All right, so you guys, so after this, the defense and the prosecution are both going to have a closing argument today. Okay, so we know that much. After the closing arguments, the jury, they're going to go from, I believe they have, 18? Okay, hold on. I think they're back in session here.
All right, we are back on. Defendant's present. Got 2 lawyers up. I assume you're calling your witness, or is there something for the court?
It's something for the court, Your Honor.
For the state, first I'll work order.
Thank you, Judge. Your Honor, the next set of witnesses are lay witnesses, and the state filed its brief 4.72 on October 18th of 2021. These witnesses are in no way character witnesses about Ahmaud Arbery. These witnesses are intended specifically by the state to provide facts about their knowledge of Mr. Arbery and that he was an avid runner.
How was that Ahmaud Arbery? What?
Defense has been beating a drum.
Endangering safety.
Oh, yeah, I'm sorry. On that one, I do think that.
You see it?
All right, you guys, I think we made it. I think we're there. I think we got this.
That the defendant was not lawfully in self-defense. But I'll try to squeeze the content in there as well.
Their signal's a little bit
And
jacked up.
I guess I'm not sure that I agree with your statement that, well, let's take a look at it. And of course, the state wants me, if I read the self-defense portions in, then they want me to repeat every time retreat and provocation, which you have opposed.
They don't.
So they're going to hear that again. What?
They don't want that anymore.
They don't want it anymore?
I'm going to withdraw that request simply because of time.
Okay. I think I'll go back to bed.
Oh boy, here come the jokes.
Okay. But in counts 2 and 3, I gave special instruction only with respect to Mr. McGinnis, because the law is different with respect to him. And we'll get to that.
Okay, very good.
But I didn't reread it with respect to the account involving Mr. Jumpsuit Man.
You would be Grosskreutz is the one that I think is where, so you've done attempted first degree with self-defense, attempted second degree with self-defense. But the way that I read it, and if I'm reading it wrong, I know the court will correct me, on page 27 of the final instructions, it simply says, here are the elements. I didn't see self-defense mentioned
You're right.
in there.
You're right. Because as I did, now, let me say, on counts, the attempt murder and the murder, on those, that's the pattern instruction. If I had my way, I think that's overly verbose, and we didn't used to do it that way, and then they came up with this, and I follow it, but I think it could be better stated, but I follow the guidance of the instruction committee because there's more of them than there is me, and they're very bright people. But and then on count 3, I gave a special instruction because of the situation with Mr. McGinnis, but I didn't on count 2 or count 5 because I relied upon the general principles of self-defense on which I instructed them. So if you want me to do it on 5, I need to do it on 2 too. When they've just, that's on 2 also. And that's right after they've just heard it. So, all right.
Well, my only concern is that the instruction makes it clear that self-defense is an issue for first degree attempt and second degree attempt. I don't know if a right.
And
so
that's because that's from the pattern instruction. I understand you're thinking, well, because I didn't discuss it, in the portion on reckless endangerment that they're going to think it's not part of it. But the last sentence tells them, and if you are satisfied beyond a reasonable doubt that the defendant's conduct was not privileged under the law of self-defense, you should find the defendant guilty.
Did you see that under the recklessly endangering safety one, Your Honor? Is that what I'm just making? Is that what you're telling me?
That's on the that's on. Excuse me, I'm reading from the fourth count here. Let's see. Let's have a look at what I said on 5.
I don't even know what they're really even talking about right now, to be honest with you guys. If you guys have any idea what the hell they talking about right now, let me know.
See, if I had set this up, I would have put a. Well, I'm not going to say what I would have done. You know, you're right. Well, maybe I misunderstood what you wanted. Did you want the whole self-defense instruction discussed again, or just the clause? And if you are not satisfied beyond a reasonable doubt that the defendant, I should say it, is all 3 elements of the crime of endangering safety of the first degree have been proved, and that the defendant is not privileged under the law of self-defense, you must find the defendant not guilty.
I think that's fine as long as the self.
You don't need the whole.
As long as they're aware that
the whole
self-defense
instruction
is an option.
Yeah, well, you're right. I was misunderstanding what your email said. So, if you are not satisfied beyond a reasonable doubt well, there's more missing there than that. You know that? There's not the clause about if you are satisfied.
What is he talking about, you guys? Let me know. All this court talk, I don't know. I'm not good at court talk.
All right, so it'll read at page 27, the fourth line will be, if you are satisfied that all 3 elements of the crime of reckless endangerment have been proved, and that the conduct of the defendant was not privileged under the law of self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as charged as submitted. If you are not so satisfied, then you must find the defendant not guilty.
Okay.
Is that satisfactory?
Heck no, that ain't satisfactory. Not guilty. Nah.
Okay. What's next?
They scared me, man.
I have nothing else on the instructions.
Defense?
So, Judge, and this is more for the record, you've already made, I think, preliminarily, you had talked a little bit about the Ritchie McGinnis instruction.
Right.
Which is on page 8 and 9.
Right.
And the position that I had taken was, one of the lines says, but the defendant does not have a privilege of self-defense as to Richard McGinnis. After that, there's discussion about self-defense and what that means. On page 9, there's a sentence that says, if the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. I had told you.
You guys let me know if the audio is coming through for the court.
There was some incongruence in that.
If you can hear this court case.
I know the court
clearly,
disagrees, but
know.
Just for the record, I wanted to make sure that that was on there. Because I do think it's confusing. However, I know it's the pattern instruction. I know you took it from the pattern.
Yeah, I'm not even going to argue with you. It is the pattern, and I'm not going to argue with you that it is confusing. But it's an accurate statement of the law. Mr. McGinnis does not have a self-defense status because the defendant has no right of self-defense as to any harm he would cause to Mr. McGinnis. And that's what the instruction is telling the jury. But if he was acting lawfully in self-defense with respect to Mr. Rosenbaum, then it kills one of the elements. I think I'm reading that right. It gives him an absolution with respect to the element of what is the precise element? It's
Number 2.
part of element, yeah. Unreasonable and substantial risk of death. It says then that the jury can't find that. Well, if they can't find that, they can't find one of the elements, so they have to find the defendant not guilty.
What?
Judge, do you think it's appropriate then on page 9 to say if the defendant was acting lawfully in self-defense as it relates to Joseph Rosenbaum?
At what point do you want that put in?
I just think that makes it clearer. I mean,
Where do you want to put in?
Where did you say?
Yeah.
On page 9, it would be so there's a subheading determining whether the beliefs were reasonable.
What the hell they're doing right now.
I think it's the third or fourth to last sentence says, if the defendant was acting lawfully in self-defense, comma,
Okay, with respect to
Joseph Rosenbaum.
With respect to Joseph Rosenbaum.
His conduct did not create an unreasonable risk to Richard McGinnis.
Yeah, I'll do that. Any objection?
No.
Okay. Okay, what's next?
Just, Your Honor, that on page, these are small, but on page 34, two of the witnesses, you said one of the witnesses had been convicted of a crime. Mr. Grosskreutz had been convicted of a crime, and Mr. Smith had been convicted of a crime for a juvenile adjudication. So I think if you just say multiple witnesses had been, something like that.
Okay.
What
number? What page is that on?
I'm sorry, 34.
Oh boy.
And we are asking for the cautionary.
Do you want the word some instead of one?
Or multiple? Yeah, some
Several?
is fine.
How many was it? 2.
That I recall.
There actually were. Well, I don't think you asked Ms. Sword about hers. There was another witness with convictions, but I don't believe the question was asked. So 2.
What was the answer? 2. All right, I'll put down 2 then.
And then there was some conversations regarding a cautionary instruction regarding Mr. Armstrong.
Yeah, and I really struggled with it.
And we had proposed the instruction to the court, which I think we took off of 245 or something like that.
Yeah.
So we are asking, based on his testimony, that the court instruct with that modified 245 instruction as relates to Mr. Armstrong.
Did you want to be heard?
Well, I would stand by what I indicated over the weekend in my email, but I believe that I'm looking up the specific instruction. Say 245?
I am sorry, but I am not following.
That's testimony of accomplices.
I don't know what the
Yeah,
hell
and
they're talking about,
that's a
what
good
they're
model for it. That was what I
was
had
expecting
planned on
these,
using if I had drafted
doing.
it myself.
Prosecution and defense to be going at it, to go ahead and close the deal. And right now they doing all this
I just don't think it's necessary. The evidence
court
was
talk.
received.
I don't know what the hell
The
they talking
points that the defense wanted to get into were made on cross-examination. Giving any kind of instruction on this would essentially be telling the fact finders how to weigh the evidence. I proposed some different wording. You should not base a verdict of guilty upon it alone unless after consideration of all the evidence you are satisfied beyond a reasonable doubt that the defendant is guilty is completely inappropriate. I can understand where it's appropriate if you're talking about accomplices, but certainly not when we're just talking about a one picture out of 100 and some odd exhibits. So I don't believe it's appropriate. I don't believe it's necessary. I believe that these arguments about pixels and zooming are specious, that their expert used a very similar software program with zooming, was cropping.
There was no objection then, you see.
I understand. There's no basis for an objection, and they know that.
I don't know that. Maybe they do, I don't know. I can't read their minds.
This is a forensically sound program used by a forensic analyst who's trained. This image was peer reviewed. If they want to discuss the proprietary algorithms and how a analyst would not know a proprietary algorithm contained in the software that they are using, that is an industry standard, they can go ahead and argue that. But to give an instruction that tells the jury essentially to ignore this evidence unless everything else proves it is way too far.
Well, this whole business about, well, I don't want to say the whole business, but the Daubert rule is the product of the abuse of so-called scientific evidence.
What's
by
up?
Attorneys.
Thanks for following.
There were companies, pension funds, individuals were bankrupted because of legal decisions that were made on the basis of so-called science, which was later shown to be garbage. So when you come in here and you tell me, well, this is what they rely on, I think that's fine, except when my common sense tells me, well, wait a minute, what's happening here when you get an image that is consistent of, I'll say it again, let's say 2,500 pixels, and you blow it up to 25,000 or 250,000, and you don't really know what fills the vacant space, that's a little struggle for me. And this is not being used to decide which camera I'm going to buy or which phone I'm going to buy when I'm at the store. This is being used to decide about whether someone's innocent or guilty of a crime. So that's why I was when the witness answered, he didn't know. And the only reason I left here, and I troubled about it, and in the end, I decided, well, wait a minute, we allowed this kind of thing to happen in DWI cases where the officers
Definitely gonna need
ask, well, how does
a lot of
the
coffee
machine work?
if this is what they're gonna be doing all morning.
I just am trained how
I
to
want to
operate
get
it.
into this, man. I want to hear the closing
But there is a difference
arguments.
there. That has already passed judicial scrutiny, and
Really
this
ain't trying to
method
hear
has
all this
been
right
judicially determined to be
I
accurate.
don't know what they're talking about.
Has that been
They're
done
just
in this?
confusing me even
I don't
more.
know. So that was when I was thinking, well, maybe I
just
should
want to
give a
hear
cautionary
what
instruction.
the defense and prosecution
I
got
ultimately,
to say to close out this thing.
you
And I want to
convinced
know.
me
I want to hear who got the best
in our
plea
exchanges that
or who's the most convincing.
I don't want to be meddling and commenting on the evidence.
This is a showdown.
I will
right
tell you
now.
this,
And this judge is all this talk.
assuming that
I don't know what he talking
there's a
about.
conviction, one or more, assuming that the other motions don't contaminate the whatever outcome there is. If it comes out at some time that the method used produces unreliable results, this is going to fall like a house of cards. Because you're basing this extremely important segment of the evidence on something that I'm really queasy about. But as I said when I left here Friday, this is the jury's case, it's not mine. And I'm going to let them decide. They have your photographs and your video, and they've got the testimony of the person who's worked with it, who knows a lot more about this stuff than I do. So I've decided to leave it alone. So I'm not going to give an instruction on it, but I've made my record on the high risk that I think it presents for the case. Okay,
Leo,
what's
you
next?
got an interesting comment. Let's see if you can spin that.
The court had modified a
There's,
little bit.
What is that?
Count
Sheldon
6,
fans?
which was the
I did.
Either I can't see the font I don't know
the
what
third
the hell
element
that word
you
is,
have
but
listed there is the dangerous weapon was a rifle that had a barrel length
my
of less than
font
16
is a
inches
little screwed up.
or an overall length
But
of
it
less than
says
26
something about
inches.
I can't
We
read.
have pulled the
But I do
transcript,
see the law should
taught
not
and
apply
looked at
when
it. Detective Andreini
someone
was
willingly
asked if this was
abuse
a
it to
short-barreled
kill
rifle.
people.
He had answered no, he did not believe that it was.
Wait, what's
That's
that?
the
What's the
only
name of that law?
information,
The self
regarding
self
Was the gun
def-
offered
oh
as an
self
exhibit?
defense.
Yes,
Okay.
That is evidence
correct.
enough. in
So you're
itself.
saying the self defense
The
law
jury can measure it.
should not apply when someone
That-
willingly
Fair
abuses
enough. I just didn't.
to
The
kill
way that I
people.
looked at it, there was no other
Well, that's the
information
thing.
that,
I mean,
that a reasonable juror could believe that count three's been met.
I think that is what
So,
So what are you telling
the
me?
I'm asking that you
defense
take it
has
from
to
them.
prove right now.
You're asking me to-
They have to prove that
To dismiss the
this
case
was in fact self-defense.
for failure to prove.
And the prosecution
Judge-
is trying to debunk that.
There have been
So,
many discussions about this count. I'm not going to rehash everything. The state
so yeah, the defense has
disagrees
to
with the
convince the
interpretation.
jury that it was in
The
fact
court-
a self-defense and not
the
just
court has
some kid playing
established.
Call of Duty.
We do not believe this jury instruction is appropriate. We do not believe that the exception or affirmative defense, or whatever you want to call it, was
What else you
properly
guys
raised.
think? What
We argued
who else
about all
got,
that on Friday. I'm not going to rehash it.
Who else wants to chime in?
I believe it should go to the jury.
While we got all
The
this
jury,
boring court talk going on.
believes that it was not proven beyond a reasonable doubt, they can return a verdict on that. But the state has objected all along, or has given its version all along. We stand by that version. I believe that this jury instruction essentially swallows the entire statute. We've gone over that before. So I believe that if they raise an exception, then it should go to the jury. We would like the standard instruction. Clearly, the court's not going to do that.
Well, up to now, the motions were motions to dismiss the complaint. And you filed a very nice brief, which well explained what the law is. And of course, we were dealing with what the complaint stated and whether the complaint stated sufficient facts to bring the case to court. And the court is confined on that kind of a motion to what's in the complaint and whether it meets the law. And as you pointed out, these defensive matters are affirmative defenses, and the DA doesn't have to plead them. So that's why I ultimately denied the motion to dismiss, although I think it ought to have been mighty clear.
Do whatever you
that
got
I
to
had
do to
big
get through
problems
this.
with this statute. I
This is
made no
going.
bones
This
about
might be.
that from the beginning. And
This might be a gut wrenching.
there always was access to the Court of Appeals all along here. Well, I guess that's not fair for me to say because I was sitting on it. But so shame on me. But
Get on with it. All this small talk and the little jokes. I just want this thing to move forward. Come on.
ultimately read the statute and have, even when I ruled on the motion to dismiss,
What?
I
Motion to
was of the
dismiss?
opinion that the statute was
What's he talking
as
about?
interpreted by the defense.
What is he talking about, y'all?
But there was not sufficient grounds to grant the motion to dismiss. Is the firearm here now?
Yes.
We can either measure it,
What?
or you can stipulate that it is.
The
It
heck
does
they
not
want to
meet what
measure the
I've
gun for? What they got to do with
stated are
anything?
the requirements. And if it is out of compliance, if the barrel length is less than 16 inches, or an overall length less than 26 inches, then I'll deny the motion. If it does not meet those specifications, then this defense motion will be granted.
We are not disputing that the barrel length is appropriate.
Isn't legal?
It is not a short-barreled shotgun or a short-barreled rifle. Yes,
Either by barrel or by overall length?
correct.
All right, and then count 6 is dismissed.
What do you say?
What's next?
One other thing, Judge. I had filed on November 8th. We had addressed a motion for mistrial with prejudice. The court had
I
taken
think
that
they're
under
gonna screw
advisement.
themselves.
What I had
If
informed
they
the
try to
court
do a mistrial
so I have filed
right now, if they actually want a mistrial,
something
and this
in writing on
goes
that.
back to
I know the
court,
court likely
because I think
hasn't
they're
had an
trying to do a
opportunity to
mistrial
review it.
with prejudice, meaning that
I don't know.
it can be
I'm
tried
assuming-
again.
Okay, I'm assuming that we're going to go obviously through.
So if it can be
closing
tried
arguments
again,
today.
they
But
might not be
I
so
did
lucky the
want
second
to,
time around, because
make
I
sure the
feel
court
like
was
they
aware that it
I
had
feel like
been
right
filed,
now the
and at
defense
some
is
point,
kind of winning
have the court
because
make a final ruling on it.
prosecution is
Just for the
struggling
record.
I will.
Okay.
to
If it's
prove
necessary.
that Kyle was acting
Okay. Came in this
not
morning?
in self-defense.
Okay, anything else?
So I think, well, I don't know,
Defendant's
understand why the
interview
defense
link
would
that
want
we
to
sent to
try to
play.
get a mistrial when they
The
are,
Washington Post
to me,
story.
they have the better
I
case.
did receive that. I did receive that.
I think the
Relates to the
prosecution
motion.
is
That's
really
the reason I asked.
struggling, and the judge is not giving them any breaks or helping them do what they need to do to prove
Well, I'm not going to take up the motion now.
that
I
Kyle
just knew there were
Rittenhouse
typical
was
problems. I
just
just wanted to make
out
sure they
here
were no.
being a vigilante.
I did receive it.
So I don't know why
Okay.
the defense
Anything else
wants a
right now?
mistrial.
Judge, are you done? Attorney Charles? Yeah. The only thing, Judge, in our arguments, we would like to indicate that pointing a loaded AR-15 at someone without reasonable justification would be
You can't
a
handle the
criminal
truth
act,
on YouTube
without
says
citing, the
anyone who
statute,
finds Kyle
but that
guilty
pointing
is anti-American.
under 941.20 is a crime. We would
Wow.
like to point that out, and we
You
just
gonna
want to
say
preview
that?
that.
You gonna go
So
there?
if there's objection, we can handle
Why do you
it
say that?
now.
Why is that? Why you got to be
wanna
anti-American
respond?
to find him
Jeff,
guilty?
This is
I mean,
once
nobody
again
told him
lying
to
on
go
the
out there with
exhibit
that
that is
long
so
gun.
far
Nobody told
out
him
of
that he
focus,
had to
and
protect
there's been nothing
property.
in the record. When I
If he wouldn't have
specifically
went
asked
with the
the
gun,
detective-
I feel like this would
Detective
never
Mueller
have
regarding
happened.
Strong arm robbery.
So, I mean,
asked about strong arm robbery while masked. I asked
Two
about
people
it.
died,
It's in the
and
record.
one person was seriously injured.
The struggle
I'm
with
having
this
a
is-
hard
and
time saying, okay, I think he should walk. Something's got to happen to this,
how do
because
we know
we
if
got
pointed at or
dead
toward
people
Mr.
dead
Zeminski
here.
or Mrs.
People lost
Zeminski
their
or
lives,
whomever?
and he had
You
no
have a
business
theory
bringing
that
that
it's pointed
gun
in that direction. I
to
agree
this
with that.
riot,
But the
protest,
statute's
whatever you want to call it.
prohibition is pretty explicit.
And
I'm not
if
sure
he was looking for trouble, he sure
The
got
evidence
it.
that you
So
have, especially because it's just the.
I don't know why not. Why can't?
just
Why not
especially,
be
but
guilty?
in
I
part
mean,
because it's just a
he
regular
he shouldn't have been there.
photograph. It's not
And when
multidimensional.
he made his bed,
Doesn't
he
show
needed to
the
sleep in it.
exact area
This is my
in which the
opinion.
firearm was
We
in.
are all
Judge,
Even
we
if you
all
see the
have
firearm.
opinions that we are
Again,
entitled to.
the photograph is
So I would like to hear
Perhaps
you guys
the
what you guys
fifth or sixth
think.
most relevant piece of evidence on this topic.
Most what?
Fifth or sixth most relevant piece of evidence on this topic. We have testimony, we have videos, I'm not going all over that again. The defense submitted their own exhibit of the FBI video with the Zeminskis
You can't
denoted
handle the
as
truth,
being
says
the only
on
two
YouTube.
that were on that
I
side
say
of
that
the
because he
Duramax.
was there to help.
Mr. Zeminski is
It is
starts
his
out by
neighborhood
the
because his father
one
lives
of the
there.
windows of the
Those people
Duramax, I guess would
deserve
be
what
the
they
rear
got. Maybe he
passenger
should
side window.
get probation
And
with a what is that,
So there's
suspended?
no real dispute that they
5
are in
years,
that area,
but that's
and that is
it.
where we argue that he is
Whoa.
pointing the weapon.
You,
It's for the jury to decide
so you
if
think he
he's
should get
pointing at
probation,
Zeminski's or
5 year
not.
probation?
So it's for the jury to
Let me
decide.
remind
It's
you,
not
he
for the jury to
did
speculate.
kill 2 people. Did die,
I mean,
not one.
Let's look at the statute.
But
That's-
2
that's a good
people
place
died,
to start.
and the third person was practically amputated. His arm was vaporized. So with 2 people being dead, okay, they lost their life. They ain't
Is it
coming back on this
941
earth. They gone.
2-0.
Their family ain't
Yeah.
gonna see them no more. 2 people dead, 1 person seriously injured. You really think 5 years probation?
And that brings up, a
I mean,
separate
that
issue,
just
I
don't seem like
suppose,
justice to me.
that what is the
But
role of
you're
Mr.
entitled to your opinion.
Rosenbaum, assuming the defendant violated that statute? That's the very theory
Leo
that the state has
said
proceeded on. In the first place,
Somebody told
is that
Kyle
the
to go out
the
there
defendant
and
was
shoot
a
people because that
vigilante
would
who
be
was
the
getting
right
himself involved
American
in
thing
something
to
that was not
do.
his concern. And now you're telling me that would
What?
justify Mr. Rosenbaum's actions? I'm kind of
I don't-
struggling with that too.
I don't think nobody told him to go
How would
shoot
that
nobody.
justify? I mean, how did
He
what
did
does the
that
jury
on
do
his
with
own.
that?
Nobody told him to go shoot nobody. He had a big gun, and he felt big.
I don't fully understand the
He
court's
felt
question.
bigger than he
I would
was.
also
that
What
night.
is pardon me?
He also pointed the weapon at Mr. Rosenbaum before the shooting. While
If
he's
he didn't
being
kill
pursued,
them,
he turns and points it at Mr.
then they would
Rosenbaum.
have
There's no
killed
question
him.
about
I don't think so.
Correct.
I don't think so. I don't think
Pardon me?
Is that he's being chased by-
Rosenbaum was. I don't know what his intentions were. Kyle said he was trying to reach for his gun, trying to take the gun. Even if he would have took the gun from Kyle, I don't think he would have killed him. I just don't understand the motive behind that or why he would do that.
Well, they've made it much more
I
complicated.
personally
To me,
don't
if
think that
points and aims,
they would have killed
points or
Kyle
aims
that
a
night.
firearm at another.
I really don't.
I'm not seeing that exact
But
language
again,
anymore.
that's my opinion.
I'm not seeing it here in the statute that there'd be a broad enough sweep to capture some wrongfulness in just pointing the firearm towards the west without evidence that it was pointed specifically at or toward another. What am I missing?
Let's see.
1A is an
we
endangers
got.
other safety by the negligent operation or handling of a dangerous weapon.
Did you start that over? I'm so
Sure. 1A is endangers another's safety by the negligent operation or handling of a dangerous weapon. We would argue that it is, if the court feels otherwise, we just simply will talk about it and not call it a
Well,
crime.
where was the firearm aimed? You say at the Zabinskis. I didn't hear the
Oh,
Zabinskis come in here and
see.
say that. Who said it?
You obviously haven't been paying attention to most of the trial.
Except for looking
They
at the video,
smacked him in the head twice with the skateboard.
and that's who's over there.
Wait,
That would be
wait,
the
wait.
only
I beg
evidence.
pardon?
Let me-
Looking at videos and indicating
Before he
that
even
those are the
shot
ones
at
who are over
two-
there,
at
that would
two
be
of
the
them.
only evidence.
I can't say. I'm not saying
I've
it
seen
didn't
people
happen.
not
I'm saying
retarded
I'm
with
saying
that.
I don't think I can
Well,
give
I
instruction to the
didn't.
jury.
I didn't hear anything about him
telling
getting
them,
hit
you know,
with the
something,
skateboard till
when
after
this
he shot
statutory,
Rosenbaum. So I don't know where you
Instruction,
getting
we-
this information that he
In our
was
closing,
hit. He was
in
smacked
our arguments,
twice
we
in the
just
head
wanted
with
to
a
say
skateboard
it's-
before
I think it would
he
be
shot
okay for you to
Rosenbaum.
say
I don't. I
state
didn't
what
hear
the
that.
law
I didn't hear nothing about that.
says, but you have to be careful.
As far as
because
I know
the jury
from
cannot be
watching the
invited
trial
to
and everything,
speculate. So
he
I
wasn't
don't
hit
wanna-
with a
I don't wanna,
skateboard
there's such a
so
universe
he
of possible
ran
statements
away
that could be made,
after he
but I
shot
don't wanna try
Rosenbaum.
to,
That's when
you know,
he was hit
rule in
with a
advance.
skateboard.
I've
So
refrained
if
from
I'm
doing that.
missing
I've tried to,
something, let me know.
because I can't read
But
your
I
mind.
didn't hear
but,
him. I didn't hear nothing about him getting hit with a skateboard twice
So I'm not
before
going to say they can't mention
the
that
shooting.
at all.
No, I don't know where
That
that's
it's
coming
unlawful
from.
to point a gun at somebody. The jurors probably have a sense of that anyway. But
Leo said, "I bet you the Proud
But as
Boys
to
or someone told him to go out
what might
there
be said, I can't tell
and
you
do
what's in
a
and out about.
self-defense murder."
Okay,
Huh.
what's next?
Interesting theory.
That's all we have.
Okay, ready for the jury? I'll probably take a break after the lengthy instructions. And
Let's see. Rosenbaum went for the gun.
let's see.
That's kill number one. The other two attacked him and hit him with a skateboard twice, while the other one had a gun pointed at him. It's on the record. Well, yeah. This Anthony Huber, the skateboarder, he hit him. I don't know about twice. I know he hit him in the back of the head or back of the neck once. I think he made contact once. And again, this is after Rosenbaum was shot. And that's when Anthony decided to chase him down and try to disarm him. So, and as far as Gage says that the gun pointed at him after he was shot in the arm. The gun went in his direction. So only Gage knows the truth as far as where he was pointing that gun and if he intended to point it. I don't know. He said that he was not pointing it at him and that the gun went that direction because of being shot in the arm. And that's what his testimony was on that. So they muted the court. They muted it. Sounds like they're trying to get the juries to come down, you guys. So hopefully we can get this court case will start to move along here. What else you guys got to say? Who else wants to chime in on some of this stuff? Let me check some other feeds here.
Okay.
Okay, you definitely have been paying more attention to the media than this case. I'm out of here. Sorry, man, but you're letting media bias push you somewhere that it shouldn't. Good luck with that. Well, you're free to do what you got to do, but it's my opinion, We're all entitled to our opinion. And that's, to me, as far as what I said is fact. This is what happened. He did not get hit with a skateboard before Rosenbaum was shot. The skateboard didn't come into play till after he shot Rosenbaum. That's when Anthony Hubert hit him with the skateboard. No, I didn't hear anything in this trial about him being hit with a skateboard before the shooting of Rosenbaum. So if I'm missing something, let me know, you guys. But as far as I know, that skateboard, he did not get hit with a skateboard till after he shot Rosenbaum, then got chased down, then he got hit with a skateboard. The judge looks like Ammerfoot. No, I like the other one, the meme that he looked like the dark Sith or whatever from Star Wars. Whatever the guy's name is, the character, I don't know the name, but it's a Star Wars character, and he looks just like him to me. It was quite funny.
Nice weekend, and we'll begin our final phase of our case, which is my instructions, and I'm going to instruct you on the principles of law which you are to follow in considering the evidence and in reaching your verdicts. It is your duty to follow all of these instructions,
okay, it looks
regardless
like the
of any
jury
opinion that you
got,
may have about what the law is or what the law ought to be.
Here, so
you must base your verdict on the law as I give it to you in these instructions. Apply that law to the facts in the case which have been properly proved by the evidence. Consider only the evidence received during the trial, and the law is given to you in these instructions. And from these things alone, guided by your soundest reason and best judgment, reach your verdict. If any of you has any impression of my opinion as to the innocence or guilt of the defendant, you must disregard that impression entirely and decide this case solely as you view the evidence. You are the sole judges of the facts, and I am the judge of the law only. Keep in mind that the information is nothing more than a written formal accusation against the defendant, accusing him of the commission of crimes. You are not to consider it as evidence against the defendant in any way, and it does not raise any inference of guilt. The information contains 6 counts of charged unlawful behavior against the defendant, and to each of these he has entered a plea of not guilty, which is a demand that the state prove every element of each crime beyond a reasonable doubt. Self-defense is an issue in this case as to each of counts 1 through 5. And I might interject here. Count 6 is no longer part of your consideration. That was the firearm charge. So that will not be something that you will need to address. You'll need to address only the first 5 counts. Self-defense is an issue in this case as to each of counts 1 through 5.
So why does everybody?
The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense.
We don't
the
have
law of
to
self-defense
believe
allows the defendant to threaten or intentionally use force against another
I can have my
only
opinion, you can have your opinion.
he believed
That's
that
cool.
there was an actual or imminent unlawful
we gotta learn how
interference with his own person,
coexist, you guys.
and he
Even
believed
if we
that
all
the
believe
amount
in
of
something
force
different,
which he
it
used
don't
or
mean that
threatened
we
to
can't
use
all,
was necessary to prevent or terminate the interference,
have a conversation.
and his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if he reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to his own person. A belief may be reasonable, even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offenses. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the standpoint of the jury now. There is no duty to retreat. However, in determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense against that attack. However, if the attack which follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense, but the person may not use or threaten force intended or likely to cause death unless he reasonably believes that he has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. Counts 4 and 5 require intent to kill as part of the elements. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent to kill have existed for any particular length of time before the act was committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to have existed at the time of the act. You cannot look into a person's mind to determine intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be confused with motive. Proof of motive is necessary, while proof of motive is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The first count of the information charges that on or about Tuesday, the 25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of another human being, Joseph D. Rosenbaum, under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk
I don't mind
of death or great bodily
everybody
harm.
having an opinion.
The circumstances
I think we're all entitled to an opinion without arguing, without fighting. It's just a conversation. I think we need to have a
Circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances relating to the conduct. If, as to the first count, you are satisfied beyond a reasonable doubt that both elements of this crime have been proved, and that the defendant was not acting lawfully in self-defense, as I have instructed you on the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree as charged in the information. If you are not so satisfied, then you must find the defendant not guilty on this count. Counts 2 and 3 of the information accuse the defendant of the crimes of recklessly endangering safety. Although the elements of each of these charges are identical, the rules of self-defense which apply to them are not. The second count of the information charges that at the same time and place, the defendant
thanks for subscribing.
Recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. The third count of the information charges that at the same time and place, the defendant recklessly endangered the safety of an unknown male under circumstances which show utter disregard for human life. First-degree reckless endangerment, as defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances related to the conduct.
Tensions are high right now in Kenosha. National Guard is out here.
What is this judge doing right now? I am so ready for this case to like move forward. I feel like we like stuck right here. Like this needs to make some progressions here. Judge, what are you doing? What's he doing, you guys? What's up? Thanks for liking the stream. I can't say your name, but what's up? I'm not going to even attempt to try to pronounce that.
When I was instructing you a moment ago on reckless homicide, I indicated there were 2 elements. There are actually 3. I did read all of the ingredients, but I'm just going to reread a portion of that instruction so it's clear that there are 3 elements to that crime. And I also used the word both of the elements, and it's actually 3. So I apologize for that mistake. And we'll stop with the reckless endangerment for a moment and return to the reckless homicide. And the elements of reckless homicide are that the defendant caused the death of another, that he did so by criminally reckless conduct, and the third element, which I read as part of the second, is that the circumstances of the defendant's conduct showed utter disregard for human life. And what tipped me off is, other than causing death, the reckless endangerment, which I've been reading now, has those same 3 elements. So utter disregard for human life is one of the elements of both crimes. And in order to convict on the first count, you must find the presence of all 3 of the elements of first-degree reckless homicide, and also find beyond a reasonable doubt that the defendant was not privileged under the law of self-defense. Is that clear? Thanks. Thank you very much. Getting back to the reckless endangerment charge with respect to Mr. McGinnis, there is evidence in this case that the defendant was acting in self-defense as to Joseph Rosenbaum.
What? There's evidence? What evidence?
The fact that the law may have allowed the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct, which showed utter disregard for human life, but the defendant does not have a privilege of self-defense with respect to Mr. McGinnis. So the defendant would enjoy a privilege of self-defense with respect to Mr. Rosenbaum if you find the factual ingredients of that. But that doesn't mean that the fact that if he endangered the safety of Mr. McGinnis was privileged under the law of self-defense, because Mr. McGinnis was not attacking him. However, You must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life, but he does not have a privilege of self-defense as to Richard McGinnis. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent interference with the defendant's person, that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended to or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily injury to himself. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now.
What's up, Thomas? How you doing, man? Thanks for liking the stream.
You should consider the evidence relating to self-defense along with all the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm to Richard McGinnis. If the defendant was acting lawfully in self-defense with respect to Joseph Rosenbaum, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of the defendant's conduct showed utter disregard for human life. If, as to each of these counts, you are satisfied beyond a reasonable doubt that the elements have been proved and that the defendant was not acting lawfully in self-defense, you should find the defendant guilty of reckless homicide of the first degree. If you are not so satisfied, then you must find the defendant not guilty. The fourth count of the information charges that at the same time and place the defendant caused the death of another human being, Anthony M. Huber, with intent to kill that person. This is a charge of intentional homicide of the first degree, and you must consider first whether the defendant is guilty of that offense. If you are not satisfied the defendant is guilty of first-degree intentional homicide, you may consider whether or not the defendant is guilty of second-degree intentional homicide or first-degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second-degree intentional homicide and first-degree reckless homicide are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant have caused the death of another. First and second degree intentional homicide require the state to prove the additional fact that the defendant have acted with the intent to kill. First-degree reckless homicide requires that the defendant acted recklessly and that the circumstances of his conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his own person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself.
Come on, you guys, let's move on.
As applied to this case, the effect of the law of self-defense is: the defendant is not guilty of any homicide offense if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his own person, or reasonably believed the force used by him, and reasonably believed that the force used by him was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of second-degree intentional homicide if he caused the death of another human being with intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of first-degree intentional homicide if he intended to cause the death of another with the intent to kill and did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of first-degree reckless homicide if the defendant caused the death of another by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. You will be asked to consider the privilege of self-defense in deciding whether the elements of first-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second-degree intentional homicide or for first-degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence,
it seems that way
you will be instructed to find the defendant not guilty. The facts necessary to constitute each crime will now be defined for you in greater detail. First-degree intentional homicide is defined in the criminal code as committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that his act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill the other. Third, that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of the first-degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of the defendant's conduct,
I hope he ain't gonna be just reading everything.
When first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether those beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide.
Man, I hope you don't go through this.
If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another with the intent to kill this is Mr. Huber, with the intent to kill, and that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of first-degree intentional homicide, and must consider whether the defendant is guilty of second-degree intentional homicide as defined in the criminal code, which is a lesser included offense of the first-degree intentional homicide. There are hierarchies of cases in the law. Typically, first degree is the highest offense. Then lesser included are crimes that are of the same nature with many common elements, but some differences. So there's a sequence of verdicts that are going to be submitted to you with respect to this count, and that's what we're going through at this time. So we'll take on now the but let me advise you, you should make every reasonable effort to agree unanimously on the charge of intentional homicide of the first degree before considering the offense of second degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first degree intentional homicide, you should consider whether the defendant is guilty of second degree intentional homicide. Before you may find the defendant guilty of intentional homicide of the second degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Second, that he acted with intent to kill another human being. And third, that he did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. These same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force which was used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state have proved one of the following. First, that a reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed he was in danger of imminent death or great bodily harm, or that the reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the standpoint of the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being with intent to kill, but did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of second-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide as defined in the criminal code, which is also a lesser included offense of first-degree intentional homicide. Again, you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide, which is a crime committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before the defendant may be found guilty of reckless homicide of the first degree, The state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another human being. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct, which means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created the unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to establish beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous the conduct was, the obviousness of the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. Consider also the defendant's conduct after the death, so as to consider also the defendant's conduct after the death, to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time that the death occurred. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, and that the defendant's conduct was not privileged under the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree, as submitted. If you are not so satisfied, then you must find the defendant not guilty on the fourth count. The fifth count of the information charges that at the same time and place, the defendant attempted to cause the death of Gage Grosskreutz with intent to kill that person, a crime of attempted first-degree intentional homicide. With respect to this charge, you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional homicide or first-degree reckless endangerment, which are less serious degrees of criminal homicide. The crimes referred to as attempted first and second-degree intentional homicide are different degrees of homicide. Again, that is the taking of the life of a human being. The degree of attempted homicide is defined by law depending on the facts and circumstances of each particular case. While the law separates intentional homicides into two degrees, there are certain elements that are common to each. Both attempted first and second-degree intentional homicide require that the defendant have intended to kill another.
You know, I'm glad I am in that courtroom.
Did acts towards the commission of that crime which indicate unequivocally, under all the circumstances,
people like Jesse
that he
Jackson
had formed
sitting
that
in the
intent
courtroom,
and would have caused the death of the
listening
other,
to this dude,
except for
reading
the
this
intervention
pamphlet?
of another person or some extraneous factor.
I would be
It will also be
snoring.
important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another under the following circumstances. Force is used for the purpose of preventing or terminating what the person reasonably believes to be an unlawful interference with his own person or by the other, and he uses only that amount of force which he reasonably believes is necessary to terminate the interference. and the person may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. If you find that the elements of attempted first or second degree intentional homicide have been proved in this case, the effect of the law of self-defense is as follows. The defendant is not guilty of either attempted first or second degree intentional homicide if he reasonably believed that he was preventing or terminating an unlawful interference with his own person, and he reasonably believed the force used was necessary to prevent death or great bodily harm to himself. He is guilty of attempted second-degree intentional homicide if he actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of attempted first-degree intentional homicide if the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to him. Because the law provides that it is the state's burden to prove all the facts necessary to constitute guilty on a reasonable doubt, you will not be asked to make a separate finding as to whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has proved the necessary facts to justify a finding of guilt
Will they just
for
jump
attempted
in already?
first or second
Somebody
degree
need to tag them
intentional
on in
homicide.
here.
If the state does not satisfy you that those facts are established by
Can
the
you imagine being a jury?
you will be instructed to
being
find
a
the
juror
defendant
right
not
now?
guilty.
It happened to listen
The
to
elements
this?
of each crime will now be defined for
I'll
you
be
in greater
straight
detail.
dozing off right now.
Before you may find the defendant guilty of attempted first-degree intentional
I'll be sitting
homicide,
in
the
there
state
like,
must prove, by evidence which satisfies you beyond a
just
reasonable
nodding
doubt,
out.
that the following three elements were present.
This
First,
is
that the
boring,
defendant intended to kill another.
Oh my goodness.
Second, that he did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of another, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone other than the defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. The third element is that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of attempted first-degree intentional homicide requires that the defendant did not actually believe the amount of force was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe that he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the amount of force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue.
All right.
You are to be concerned only with
So
what the defendant
you can't
actually
handle
believed.
the truth.
Whether
Came back
these
to the
beliefs are
stream.
reasonable is
Let's see what you got to
important only
say,
if you
because
later consider whether the
this
defendant
judge is
is
boring me
guilty
to death.
of
So
attempted
yes, I would
second-degree
love to hear what you got to
intentional
say.
homicide.
Let me bring the comment
If,
in.
as to the fifth count, you are satisfied beyond a reasonable doubt that the defendant intended to kill another human being, and that his acts demonstrate unequivocally that the defendant intended to kill and would have killed the other except for the intervention of another person or some other extraneous factor, and that he did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of attempted first-degree intentional homicide. If you are not so satisfied, then you must find the defendant not guilty of attempted first-degree intentional homicide, and must consider whether the defendant is guilty of attempted second-degree homicide, intentional, which is a lesser included offense of intentional homicide of the first degree. Again, you should make every reasonable effort to agree unanimously on the charge of attempted first-degree intentional homicide before considering the offense of attempted second-degree intentional homicide. However, after a full and complete consideration of the evidence, You conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first-degree intentional homicide. You should consider whether the defendant is guilty of attempted second-degree intentional homicide. Before you may find the defendant guilty of second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant intended to kill another. Second, that he did acts which demonstrate unequivocally, under all of the circumstances, that he had formed that intent and would have caused the death of another human being, except for the intervention of another person or some other extraneous factor. The third element is that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of intent to kill, unequivocally, another person, and extraneous factor. The same definitions apply to your consideration of attempted second-degree intentional homicide. The third element of attempted second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state have proved
like the judge is just repeating
any
something.
one of the following. First, that the reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed that he was in danger of imminent death or great bodily harm, or that a reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant
I
under
get
the
what you're saying.
circumstances existing
You can't
at
handle
the time of the
the
alleged
truth.
conduct.
But there was no one was in
If as to
danger.
the fifth count you were satisfied beyond a reasonable
The only
doubt
person that
the
was
defendant
dangerous
intended to kill,
was
and
Kyle
that the defendant's
that-
acts
on day
demonstrated
two.
unequivocally that the defendant
I
intended to
don't.
kill
Day
and
one
would have
was
killed
a little
another,
crazy.
except
There
for
were
the intervention
fires
of
and
another
things like
person
that.
or some
But
other
day two,
extraneous factor,
I don't even think
and
there
that the
were
defendant
any
did
fires.
not reasonably believe that he was
Or maybe
preventing
it
or
was a
terminating an
couple.
unlawful
But
interference
as far as
with
violence
his
or
own
anything,
person, or did
the
not
only
reasonably
violence from
believe
that
the
night came
force
from
used
Kyle.
was necessary to prevent imminent death or great bodily harm to himself. You should find the defendant guilty of attempted second-degree intentional homicide. If you are not so satisfied beyond a reasonable doubt that the defendant is guilty of attempted first or second-degree intentional homicide, you must determine whether the defendant is guilty of the lesser included offense of first-degree recklessly endangering safety,
I mean, I get what you're saying, man, but
as defined in the criminal code, which is a
don't-
lesser included offense of attempted first and
I don't
second-degree
see what Kyle was trying to defend.
intentional homicide.
That he had to kill
First-degree
somebody.
recklessly endangering safety is defined
It
in the
was not
criminal
that
code is
serious.
committed
You
by
have to
one
take
who
a life
recklessly
over
endangers the
some
safety
burning
of
cars
another
or
human being under
whatever.
circumstances which show utter disregard for
I
human
just
life.
don't see.
Before you may find the defendant guilty of first-degree
I
reckless
feel like
endangerment, the state
he
must
was the
prove by
problem
evidence
that night.
which
He brought
satisfies
that
you
gun.
beyond a reasonable
He was
doubt that the
irritating
following
people.
three elements were present.
Um,
First, that the
He
defendant
was the
endangered
danger,
the
in
safety
my
of another
opinion.
human being. Second, that he did so by criminally reckless conduct, which means that his conduct created a risk of death or great bodily harm to another, and that the risk of death or great bodily harm was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm
I
means
don't know if
injury
Kyle
which
was actually
creates a
shot
substantial
at.
risk of death
I know there are
or
other
which causes
guys with
permanent,
guns. I
serious-
think they were
serious permanent
firing off
or
guns,
which causes a
but I don't
permanent or
think any of
protracted
them
loss or impairment of the
were
function
intentionally
of any bodily
trying
member
to
or
shoot
organ
Kyle.
or other
They're
serious
just
bodily injury.
popping their guns off. From
Third,
what I
that
know.
the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for life and all other facts and circumstances relating to the conduct. If you are satisfied that all three elements of this offense have been proved beyond a reasonable doubt, and that the state has proved beyond a reasonable doubt that the defendant was not acting lawfully in self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as submitted. If you are not so satisfied, then you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of any sequence of offenses. So you can return only one verdict per count. You should consider the charged offense first. If you find unanimously that the defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you
I know Rosenbaum made a threat that he would kill him.
Did not commit the greater crime.
I think the point I'm trying to make is that
self-defense.
I just feel like it was him bringing that gun that brought so much attention to him, and that attention was negative. And out of that attention came a negative event, the shootings, the killings. Had he left that gun at home, because he said he wanted to just help people and be a medic or an EMT or whatever he wanted to do, had he just brought us a kit, what is that? I'm trying to think of the heck am I thinking of? A first aid kit. Had he just brought a first aid kit and not a gun, I guarantee you this would never happen this night. This would have all been avoided. He brought on too much negative attention by having that big ass gun. I mean, I just feel like he brought this on himself. Had he not brought a gun, I guarantee you nobody would have died that night. That is my opinion. And if anybody else want to chime in, if you guys feel differently, feel free to tell me what you guys think. But I think this trouble came to him because he had that gun, and it stood out. And he stood out because of that gun and got himself in trouble. Well, I don't know if you've seen the video or not, but there is a video of Kyle saying if he had a gun, he would shoot them all. So I don't know. I know that the prosecution could not use that video, but there is a video that when he's talking to a friend, he clearly said that if he had a gun, he'd shoot all of them. So there you go. I mean, that's what he said. This came out of his mouth. And what did he do? He shot people like he said he would. So, hey, I'm just telling you the facts here. If he had left a gun, he had been either dead or been beaten senseless when he tried to put out that dumpster fire. Maybe he should have had a smaller gun, but at least this one was noticeable. I don't agree. I feel like if he didn't have a gun,
the concern that
he could have came home that night and everything would have been all good.
I worked with the instructions.
I really do.
All weekend, and we discussed them by email, and then I'm reading them, and little things are striking me as I read them. But the jurors are never told to actually discuss self-defense except in the context of charged offenses. And what I was about to say to the jury, and decided I better talk to you people beforehand, is if the jury gets into a discussion of a charged offense, any charged offense, but let's use this one as an example, and they decide that the elements are there and he wasn't acting lawfully in self-defense, they're done. They never discuss the lessers. What?
Was or was not acting lawfully in self-defense?
Well, let's say if they decide the elements are there, but he was not acting lawfully in self-defense, they're done. Then they find him guilty of the charged crime. What if they if they discuss count 1, or count 5, I should say, and decide that the elements are there, but they all decide it was privileged under the law of self-defense. They're not, is there anywhere that they're being told, are they being told, you're done? See, under the old law, we did do that. Is that in here? Where is it saying that?
I mean,
that's
I
when
would be,
used to
I
construct
don't,
these from
if
scratch.
it was my neighborhood,
And
I'd be,
I would tell
pissed
the jury
off and
which
everything,
I was
but
just doing now.
I'm not going to go in the
that,
house and go get a
once
gun
you have exhausted this,
and try to
you're done.
threaten people or intimidate
as opposed
people.
to having them needlessly go through these lessons
Oh.
if they've already concluded that.
Yeah, that's,
and this is a
I
case
got to
where this
stick
could
by
happen.
that.
I'm not
I
saying it
really
should or
think it
would.
was him having that
I'm saying
gun
it could,
that
they would
led to the
decide, well,
events of that
elements
night.
are there, and
A
then they
lot
make a
of-
decision.
I know a lot of
If
people
all
do
them
not
say,
agree.
Well, they all vote not guilty on
but
the basis of.
I just know that if he did not have that gun, things would have went differently that
valid
night.
self-defense.
It would have been like any other night.
Then
It would have been like day
they should
one.
not be considering
People just protesting and
lesser included.
and
Am I
running
wrong
away
about
from
that?
tear gas and pepper
So if
balls.
they find perfect self-defense on the charged count,
Yeah.
they should be told,
I
You see
kind
what
of agree with
this-
Leo on
yeah,
this
I'm
one.
sorry.
I mean, I understand where the court's coming
Doesn't
from.
matter if Kyle is
I guess
good
they
or
could
not.
consider
Kyle
the other
should
ones
not
in
have been
30
there.
seconds and just find,
I
go down to
agree.
be
I
not
gotta
guilty,
agree.
but.
They're so complicated as it is.
No, I understand.
I feel terrible about giving this kind of stuff. It's just so, well, anyway. See what the instruction is telling them that, kind of cryptically. It says if after, it tells them if after a full discussion, it says, however, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, I'm going back to a different count, you should consider whether the defendant is guilty. So it is telling them, yeah, I just think it's kind of unclear.
I think it's very unclear. And what you're saying is the law. If they all agree that the elements are met and there's a privilege, you don't go any further.
Pardon me?
I believe the pattern instruction makes that clear enough. If they can unanimously agree, which includes the privilege, they're done. They don't have to go forward.
Where does it use? It says you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. So, there, I don't think it's not the way a person would speak if he wanted to make things clear. And I'm not saying anyone deliberately is trying to make things
hope to see you
unclear,
back.
but
I mean, I understand where you're coming from. I just don't agree with it. I don't agree with your reasoning on it.
don't do that. People will find out our lawyers.
That's all good. I mean, we don't have to agree. We can agree to disagree.
If the court did wish to make it clear, I would just say, just explain if you're unanimous either way on the first count, there's no need to go to the lessers.
Yeah, I think that's a good way to do it. I think I'll tell them that in any sequence, if there are lessers submitted to them, once they've discussed the highest count, if they are unanimous either way, then they're done. Does that make sense? No, Mr. Binger is having a problem with that, and let's see what he is, or what he's... I don't like the way I said that either.
Guys, this is dragging, man. I really thought this was gonna be like, I thought this was gonna be a show to watch. Like, go get your popcorn and let the defense go and the prosecution go at it. But this is like,
How about this?
this is depressing.
In any count where there are multiple verdicts submitted to you, if at any point in your deliberations you are unanimous either as to both the elements, presence or absence of the elements of the crime, and the presence or absence of the right of self-defense, you need go no further.
The reason I was shaking my head, Your Honor, is because, let's take Anthony Huber's counts, for example.
Yeah.
If the jury is unanimous that he is guilty of first-degree intentional homicide, they go no further.
Right.
If they are unanimous that he's not guilty of first-degree intentional homicide, then they are instructed to consider second-degree intentional homicide.
Only if they're not satisfied that it was done in self-defense. If they, for example, if in your example, if they discussed it and said, well, sure, the elements of attempt murder are there, and then they go around the table and they say, well, we all think it's not self-defense, then guilty. If they all say we don't think it's, well, actually, if they all say we don't think it's self-defense, then it's not guilty. And what the jury is being told is if you can't agree unanimously, then consider these lessers. But I don't think it's so clear as it should be.
It says if you are not so satisfied.
I know it. Well, that's at the very end.
And I think what the court was originally proposing is telling the jury that if you're unanimous on the charged count one way or the other, then you go no further.
I like that.
That's not the law.
That's a good point,
If you're
Thomas.
unanimous on,
This will be a good
So, for
trial
example,
to teach
no, if you're
people in law
unanimous
school
on
what
the
not
legal
to do.
question.
Especially as a
Intentional.
prosecutor. I think the prosecutor started off terribly.
Well, you're right, because
The
it could be an
prosecutor was
elements
like
issue.
a defense team, the way
jury-
he was,
Maybe the constructions committee is
you
right.
know,
The jury
he had all
only
the wrong
goes to lesser
witnesses
included if
that were not on
they
his
are
side.
either
and
unable to
it
agree
just made
on
him
the
look
charge
bad,
count,
and it was
or
terrible
if they're
watching.
unanimous not guilty on the charge count, then they go to the lesser included. So there is no requirement that they be unanimous on the charge count to move to the lesser.
No, they shouldn't be unanimous. If they're unanimous, then they're done. That's what
Yeah,
I'm trying
Leo,
to
I
tell
agree
them.
with that.
But I don't know how to say it.
But
I
that's
mean,
not
we
true,
all
because
went
if
out
they're
and
unanimous on
did
first-degree
what Kyle
intentional
did that night
homicide,
and played
what
Call
they're
of Duty.
concluding at that point is that the defendant,
It would
either the
be-
elements
it would
are
have
met,
been
or
a mess,
the defendant
a
actually
nightmare.
believed that deadly force was necessary. They would still then have to consider the second-degree intentional, because it changes the self-defense into the objective, reasonable one. So they can be unanimous on count one. Let's take Huber, for example. They can be unanimous on the first-degree intentional homicide. They can be unanimous on that, and in the defendant's favor. But they still have to then move to the second element, or to the lesser included.
You might be right.
Perfect self-defense.
Pardon me?
If it's perfect self-defense, it's perfect self-defense for everything. But they're not told to consider perfect self-defense on first-degree intentional homicide. They're specifically told.
Well, yeah, you're right. He's right.
They're not told to consider that until second-degree intentional homicide. The instructions, Your Honor, are the pattern instructions. I understand your point that if we had to redraft them today from scratch, maybe we could do better. But I'm sure we could. But we need to follow them, and I don't think deviation is appropriate.
I think you're right. And they are certainly correct in what they say. I just think that they're not clear. But maybe they are. I don't know. Now let's see how much damage I've done already by my last paragraph. So
did
can
a
you go
whole
back to
lot
what
of
the
damage.
last thing I said to the jury?
Just talking. Trust me. Yeah. It was like Purge that night. That night was crazy, man. Free for all is what that was like.
Is guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, and then that's when you stopped in mid-sentence.
So the first part was right. Did not commit the greater crime and was acting lawfully in self-defense. You know, if he was acting lawfully in self-defense, the ball game's over. Yeah.
What? Man. Get out of here. What are you talking about?
I think that's correct. Even your suggestion is seductive, Mr. Binger, but but see, they're not asked to consider that. That's where I'm having the problem. You know, and they even make reference to it. They even make reference to it. I think maybe I read in one of the comments. They talk about we don't have, like some states do. They have a question right off the bat.
Kyle's the only one on trial because he's the only one that killed 2 people that night.
The answer to that, yes.
He's the only one that shot anybody that night.
We've got it interlaced in all.
That's
these
why he's on trial.
And,
nobody else killed anybody that night. Kyle was the
no. Does anyone have
the
any
one
objection
doing
to
the
what I've already
shooting and killing
told the jury?
on day 2.
And tell them what?
Just what we said. If you find perfect self-defense, you don't go on to the next count. It's over.
What?
I understand what the term perfect self-defense means, but we haven't told the jury what that means. We're deviating from the standard instructions here, and the words perfect self-defense don't have a meaning to ordinary people, would require further definition from the court, and now we're going much further afield. I also have a problem with the wording of, you know, if you find the defendant is justified in his self-defense, because we've instructed them on his own subjective self-defense belief, which is a defense to the first-degree intentional homicide, and then we've given him the instruction on what the law considers to be objective self-defense, is what a reasonable person would think. When the wording that was just read by the Madam Court reporter doesn't delineate between those two things, and I think, as I said, and I've repeated here several times, I think the more we deviate from these standard instructions, the more confusion it causes. Counsel has asked you to read the self-defense individually on each count. So they're already being told on each count that you are to consider the final thing is the objective self-defense, and that is if you find that, then he's not guilty. And to say across the board that you find self-defense is a defense to everything is not technically true, because there are different self-defense claims as to the different counts. So, for example, he may be justified to self-defense as to Rosenbaum, but not as to Huber. So a blanket statement that says anytime you find justified self-defense, he's not guilty, is not technically true.
Well, so, it is if you're talking just about an individual count.
But I was saying a blanket
and
statement.
I think what I'm going to tell them, in addition to what I've already said, is if they are discussing any count that has multiple possible verdicts.
I think that the standard instruction already spells that out, Your Honor. I agree. If we had to do it from scratch, we could do it better, but I don't think we should deviate any further, because I think it's causing confusion. What the Madam Court reporter just read back, for example,
could be construed as saying anytime with regard to any count you find justified self-defense, he walks on all 5 counts. And that is absolutely not true.
Bounce back and forth, and he definitely has a bias.
I intend to tell that, but what's already been said gives that implication. And again, I just worry that the more we deviate from these standard instructions, the more we get into these issues. I think we should stick with what you drafted, which has been sent to the parties. We've all agreed on them, and I am leery of any additional language that hasn't been cleared by the parties and could cause further confusion.
Well, I could say that whenever I've dealt with lesser included, I do give a little talk about how they should address them. And this is a more complicated
you
case.
You can't handle the truth
than any, frankly, that I can remember.
No one should have died, regardless if it was a riot. I'm not even going to say it was a riot. It was a protest.
I don't want to step into something.
I wouldn't call that a riot on day 2. Day 1 was way worse.
Though, because I've made a statement about it.
And yes, I would probably call day 1 a riot, but day 2 was more of a protest.
I think I probably should give the alternative, which
is. And just because you're out there exercising your rights,
like he did,
don't mean you should get a death sentence.
Acted lawfully.
So I mean, I just can't agree with that.
They're instructed on that. So I think the correct statement is, if as to any of the cases with multiple submissions, if on any individual count they find in their consideration of the charged offense that the defendant acted lawfully in self-defense, they're done. Any objection?
No.
Okay.
While we're talking about the jury instructions, it was noticed as you read them on page 10, which is count 3, it should be first-degree reckless endangerment, and it's written and you read homicide, which it's not a homicide count. So
on page 10.
It's on page 10 on count, still at the end of count 3. It says you should find the defendant guilty of first.
Yeah, you're right. Homicide. You're right. It is in there as homicide. We didn't catch that last night when we talked about them. I sent you 3 drafts.
We got another free Kyle.
But you know what? Should I just leave that alone? They'll know that. I'll change it in the print.
Red 5 golf. Free Kyle.
Okay, thanks.
Are you anticipating closing before lunch now? It's after 11.
Entitled to that. Opinion.
How long are you going to talk in your first sequence?
I'm going to try and limit myself to 2 hours.
Rittenhouse is.
Are you troubled by taking a break in the middle of your
I'm not going to take that away from you.
Well, let's just kind of plan on around noon because the lunch has already been ordered. So, and I'm not going to comment on the lunch. So let's ask the jurors to come back in, please. So I'll take a break why don't you, around, whenever you're comfortable, around noon, just ask for the break. Yeah, well, when he's the commander of I don't want to interrupt him at a time he doesn't want to be.
Did you get my IA?
I did.
Leo says, I want the government to take purge up to a debate and make it happen. No, I'm good on that. I don't need everybody walk around trying to kill me. Can you imagine if that really existed? That'd be crazy. You can't handle the truth on YouTube, said it no.
So, folks, what I was talking about with the cases that you have,
here the judge got to say
multiple possible verdicts submitted to you for consideration, when you address the charged crime, if in your discussions you conclude that the elements are present and the defendant was not acting lawfully in self-defense, then you needn't go any further. You can return your verdict of guilt based upon that conclusion. If in your discussions as to any individual count of those with multiple possible verdicts, in your initial discussion, if you decide that the defendant acted lawfully in self-defense, you're done. And you can return a not guilty verdict without considering the lesser offenses. Any question about that? It hopefully will become clear. I'm going to give you written instructions because I know this is arduous going through this, but every bit of it is important. But you'll get written instructions for your reference in considering these things. Counts 1 through 5, that's all the counts now, each contain the guilty verdicts of any submitted offense contain a question based upon the allegation of the information that the defendant committed the crime while using a dangerous weapon. If you find the defendant guilty on any of the counts, you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you may find answer the question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, then the question must be answered no. In reaching your evidence, examine the evidence. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who called the witness. Second, any exhibits which have been received, whether or not they accompany you to the jury room. Third, any facts which the lawyers have agreed or stipulated, or which I have directed you to find. Anything that you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at this trial. You should disregard entirely any question to which I did not permit an answer. Do not guess what the witness's answer might have been, and if the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and duty to object to what they feel are improper questions asked of witnesses, and to the receipt of other evidence which they believe is not properly admissible. You should not draw any inference or conclusions from the fact that an objection is made. By allowing testimony or other evidence to be received over objection, I did not mean to indicate any opinion as to that evidence. You jurors are the sole judges of the believability
you're kind
of the
being
witnesses
contradicted
and of the
to
weight
what you're
of the
saying.
evidence.
You said that
At the beginning of the trial, I described the charges
we can't
against
allow
the
our
defendant, counts
neighborhood
6 and 7,
for our
which
family's
respectively
lives to be
charged
put
possession
at
of a firearm
risk
by a minor and
simply
curfew
because a
violation,
political mob
have been disposed of
decides
and
to
are no
take the
longer
law
part of
into
this
their own
case.
hands.
The other counts
That's
remain.
what you said.
Do not guess
But
about
Kyle
or concern
Rittenhouse
yourselves with the
took the
reasons
law in
for
his
these
own
dispositions.
hands when he
It must
decided
not
to go
affect your
out there with a
consideration of
gun
the charges
and then use that
that
gun.
remain.
He
Do not
did
consider evidence
just
that
what you're
related only
saying.
to
He
the
took the
counts
law into his
which have
own
been
hands.
disposed of.
So why is it right for him to do it?
During the trial, I have ordered certain
But nobody else.
testimony stricken, and you must disregard all such stricken testimony. Exhibits become evidence only when received by the court. An exhibit which was marked for identification but not received is not evidence. Whether or not, is not evidence. An exhibit received is evidence whether or not it accompanies you to the jury room. Remarks of the lawyers are not evidence, and if the remarks suggest certain facts not in evidence, disregard the suggestion. You should consider carefully the closing arguments of the attorneys, but their arguments, opinions, and
they don't
conclusions
pick it
are
up,
not
you
evidence.
guys.
Draw your own
Somebody
conclusions
is
from the evidence
die of boredom.
and decide upon your verdict upon the evidence under the instructions given you by the court. I have taken judicial notice of certain facts, and you are directed to accept them as true. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to any statement. In evaluating each statement, you must consider 3 things: whether the statement was actually made by the defendant, only so much of a statement as was actually made by a person.
The only
may
reason
be
why
considered
Kyle was
an
up
evidence.
against so many people is because these people
Whether the statement was
were
accurately
trying to
restated here at
disarm
the trial,
him. They were trying
whether
to
the statement or any part of it ought to be believed.
keep other people
You should
from
consider
being
the facts
shot.
and
He had already shot
circumstances
3 people.
surrounding the making of each statement,
So anybody
along
that
with all other evidence,
came up to
determining how
him
much
or whatever,
weight,
they just
if any,
simply wanted to
the
disarm
statement
him.
deserves. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, and you may give it such weight in considering your verdicts. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, witnesses may testify only about facts. However, witnesses with specialized knowledge in particular fields may give opinions in those fields. In determining the weight that you give to these opinions, you should consider the qualifications and credibility of the expert, the facts upon which the opinions are based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any
I can't
witness's
agree with
opinion.
it.
It is your duty as jurists to scrutinize and weigh the testimony of the
I think you're wrong on
witnesses
this one.
and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses, and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness is interested or disinterested in the outcome of this trial, conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had to know and observe the matters and things about which testimony was given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias or prejudice, if any has been shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony, and then give the testimony of each witness the weight you believe it is entitled to receive. The defendant has testified in this case, and you should not discredit his testimony just because he is charged with a crime. Use the same factors to determine the credibility and weight of the defendant's testimony that you use to evaluate the testimony of other witnesses. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and your experience. In your everyday lives, you determine for yourselves the reliability of statements made to you by others, and you should do the same thing here. Evidence has been received that 2 of the witnesses in this trial have previously been convicted of crimes. This evidence was received solely because it bears upon their character for truthfulness. It must not be used for any other purpose. We're going to hear the closing. You know what? Does anybody want a break, even just a short one, or not? You want to go right into your discussion?
Yep,
Anybody
we
need
want a break. Give us a break.
We're going to hear the closing arguments of the attorneys now, and they.
This dude, how does he do it without taking a break?
We follow the classical debate format
just
in the
going
court. That is
talk
that
and
the
talk.
the proponent of a proposition is entitled to give the first and the last argument. So Mr. Binger will address you first on behalf of the state, then
He's gonna have us listen to
Mr.
his closing
Richards for the
arguments after he
defense,
didn't talk
and then after
for about 2 hours.
his remarks, one of the attorneys for the state will
Oh,
be
my goodness.
addressing you on behalf of the
You
state
know
in
what? He doing that on
rebuttal,
purpose,
limited to
man.
rebuttal of things
He's
stated
gonna
by
let him. He's
Mr.
gonna take a
Richards during
long,
his
nice break
presentation.
before they hear the defense closing arguments.
We're going to break, obviously. I'm not going to make you sit there for 5 hours, unless you want to. So we'll break. I asked Mr. Binger while you were out of the room if he was comfortable with breaking his argument in parts, and he indicated he was. So at a time he thinks is appropriate, around noon, we'll take our lunch break and then pick up this afternoon. And then after all of the arguments have been presented, I'll give you about 3 or 4 more minutes of instruction, and then we'll do our striking with the tumbler over there, and it'll be yours. So let me ask you.
Do you have the pointer? The sister's pointer.
Which one do you want?
The sister's pointer.
The sister's pointer? Okay. We'll take a vote right now. Supposing the case arguments are finished at 4:30, 5 o'clock, and we'll be working well to get there. How many would like to begin their deliberations tonight and stay until a later hour? Or how many would like to come back and start fresh in the morning? And the cutoff point would be, say we got finished by 4 and I give you the case. The latest I would let you go if you didn't want to stay late would probably be about 5 o'clock. So I don't know how much you'd get done, but you'd have the option to get started this today, or we just start fresh in the morning if we finish up any time after 3:30 or 4 o'clock. So how many would want to continue on today? 1, 2.
I want to see how many jurors
6,
want to continue today.
7,
Because this is going to be a long-ass day.
8 out of, what do we got, 18? How many would rather come back fresh tomorrow?
Me?
Knowing that some of you aren't
I'll come
coming
back tomorrow.
Okay, and of course, as always, I'll make the final decision, but I certainly will try to follow your wishes. So, okay, with that, Mr. Binger, it's yours.
Thank you, Judge.
I never blocked you. You
Good
can't
morning,
handle
ladies and
the
gentlemen.
truth.
I want to assure you
never
that
blocked
everything
you,
the
never
judge
said I was
just
gonna
read to
block
you,
you.
you'll
I
get a
don't know
copy of,
where
so
that
you'll have a
came-
chance
where
to
that's
look it
coming
over yourself. You don't have to memorize everything he just told you. I think it's no surprise that this is a case that there's a lot of noise and a lot of static surrounding
I
it.
did not block you from
So
viewing
what I'd
the
like to do at
stream.
the
I don't know
beginning
why-
is crystallize
why
it
you
in a
saying
nutshell
that.
for you and keep it as simple as possible. This is a case in which a 17-year-old teenager killed 2 unarmed men
You are
and
not
severely
blocked.
wounded a third
I
person
did not block
with an
you with
AR-15 that did not belong to him. This isn't a situation where he was protecting his home or his family. He killed people after traveling here from Antioch, Illinois, and staying out after a citywide curfew.
Your Honor, I'm going to object. There's no curfew charge anymore. There's no gun charge.
Although he claimed
There's no charge, but, and there has been some discussion about the lawfulness of the curfew, not in this case, but elsewhere. But there had been a curfew announced. That does not mean that it was technically lawfully a legal curfew, but there had been an announced curfew, so I'll leave it at that.
And it was a curfew that all the rest of us here in Kenosha were aware of, and I think most people, most reasonable people, obeyed. Although the defendant claimed to be protecting a business that he wasn't familiar with, the actual killings in this case had nothing to do with that. And he also spent the entire evening lying about the fact that he was an EMT. None of the things that I just told you are in doubt in this case. So when we think about the defendant, I'd like you to consider, as you think about this case, what his true motivations were. Was this a situation where he sincerely cared about Car Source, even though he'd never heard of it, never bought anything there, never worked there, and not even its owners were out there that night protecting it? Was he genuinely interested in helping people? He ran around with an AR-15 all night and lied about being an EMT. Does that suggest to you that he genuinely is there to help? He's not there for the same purpose as the protesters. So why was he there that night? When you think about these things, I think there are some things that we can all agree on. In America, it's hard these days. People are polarized, and there's a lot of political issues back and forth. And the judge has made it clear this case is not about politics. There is common ground here. We have all agreed, and I asked you this 2 weeks ago today. Raise your hand if you agree life is more important than property. And all of you raised your hand. We also agree that no one person's life is more valuable than another. You don't get to kill someone simply because they're a drug dealer. You don't weigh a pastor's life over a teacher's life. You don't weigh a police officer's life over an engineer's life. All life is sacred. I think we can also agree that we shouldn't have 17-year-olds running around our streets with AR-15s, because this is exactly what happens. And finally, I want you to keep in mind that we've all read stories and heard about heroes that step in to stop an active shooter or to give their life to save others. In fact, many people in Wisconsin went out and got carrying concealed weapon permits just so that they could be there in case there was an active shooter and wanting to stop them. So when you consider this case, look for the truth. So many people look at this case and they see what they want to see. They have a preconceived notion and they tailor the facts to fit whatever they believe. And you all agreed to keep an open mind. You all told us you didn't have any of those preconceived notions. Now you've heard the evidence, and it's time to search for the truth. So consider, for example, whether or not it's heroic or honorable to provoke and shoot unarmed people. Consider whether it makes someone a hero when they lie about being an EMT. I think all of us are familiar with someone who does the sorts of things that the defendant has done. They enjoy the thrill of going around and telling people what to do without the courage or the honor to back it up.
So far, I'm liking what he's saying, man.
So.
He coming with it. Come on.
And when you think about the defendant's behavior in this case, contrast it with Anthony Huber, a man who was there because he knew Jacob Blake, who carried his skateboard everywhere, and who rushed towards danger to save other people's lives. So when I talk to you here in my closing argument, I'm going to focus first on the murders that the defendant committed. Second, I'm going to address some background issues, give you some context, and talk about some of the things that I don't think are relevant to this case. And finally, I'm going to tie it all into the jury instructions that the judge just gave you. As prosecutors in this case, my colleague Jim Krause and I have tried to present you with all of the relevant evidence that we think you should consider in this case. And I told one of you in jury selection that at the end of this, you would be the expert. You would have all the information. You would be the one who would know all about this case and make that decision. And that's what we've tried to do. So let's go to August 25th, 2020. The defendant came from outside our community, carrying a gun that wasn't his, because he expected and anticipated violence that night. And he pretended to guard what turned out to be an empty building owned by people he'd never even met, while fraudulently claiming all night long to be an EMT.
Yes, this is true.
There were a lot of people out that night. Some people stayed home protecting their homes and their families. Others went to their businesses, boarded them up, and protected them. And a lot of those people had weapons. A lot of them had guns. There were other people who came along to protect Car Source or Ultimate Gas or other businesses. And many of them were armed with AR-15s, just like the defendant. In fact, you're going to see a video, and you've already seen it, of a clash between people with AR-15s at Ultimate Gas and other folks that are, I guess, protesters, and there's people getting in people's faces, there's yelling, there's shouting, there's even shoving. And yet, in this entire sequence of events, from the shooting of Jacob Blake on Sunday, August 23rd, 2020, all the way after that, everything this community went through, the only person who shot and killed anyone was the defendant.
Kyle.
Yes, there was property damage. No one's here to defend that. No one's here to tell you it's okay to commit arson or looting. No one's here to tell you it's okay to be rioters. I'm not defending any of that. You know, because you've been told in the testimony, I'm prosecuting Joseph Ziminski for arson. That's not okay. But what you don't get to do is kill someone on the street for committing arson. So let's keep that in mind when we're talking about the people involved in this case. So let's begin with the provocation and the murder of Joseph Rosenbaum, because it's all captured on video. As the defendant and Mr. Rosenbaum arrive at the 63rd Street car source, Mr. Rosenbaum is ahead of the defendant. And as you see in the FBI video, when Mr. Rosenbaum starts to run, the defendant starts to run as well at the same time, as if he's pursuing him. Mr. Rosenbaum could not have possibly have known the defendant is behind him. There's no indication in this record that he knew the defendant was there. It's not an ambush. It's not a situation where he goes there and lays in wait for the defendant. The defendant arrives at that location, and you hear him yell, "Friendly, friendly, friendly," because he's aware of the fact that the people that he's about to confront are hostile to him. And I'm going to show you in a moment the video in which the first thing he does when he arrives at that location is drops the fire extinguisher that he's holding in his left hand so he can raise the gun with his right and left hands and point it. This is when you hear someone, I think the testimony is Rosenbaum, it's not clear to me, but either way, yell, "Gun, gun, gun." And then Mr. Rosenbaum charges around to try and stop the defendant from pointing his gun or shooting anyone. So let's take a look at some of that video. This is Exhibit 73, the full drone video. And as we've pointed out to you before, and Jim will point out to you here in a second on the screen, when the defendant originally arrives at that scene, the first thing you see him do is drop the fire extinguisher and point his weapon at people. And then the chase occurs right after that. And you're going to see that entire sequence of events here on the full drone video. The defendant turns as he's being pursued and points the gun at Mr. Rosenbaum. And then as he enters the area between the parked cars, he slows and turns, and before Mr. Rosenbaum can even come close, he fires at him, shooting and knocking him to the ground. Now I'm going to show you the slowed down and zoomed in video of the defendant when he first gets there. And Mr. Krause is going to help me by directing your attention on the larger screen here to exactly where you will see the defendant.
I'm listening to you. You can't handle the truth.
I'm going to replay it a few times so you can see quite clearly
that
the defendant sets the fire extinguisher on the ground with his left hand and then brings his left hand over to the gun and raises it and points. check the gun. Make sure it's empty. Under Wisconsin law, you're not allowed to run around and point your gun at people. This is the provocation. This is what starts this incident. The defendant rushes in and immediately points the gun.
Sorry about that, Leo.
And as you'll see in a little bit, Mr. Rosenbaum doesn't take kindly to people pointing guns. I don't think anyone does. That's not unusual. No one wants to have the gun pointed at them, and no one wants to watch anyone else do this to someone else. We have the gun. It is in evidence as exhibit number 28. I'm having the detectives check it to make sure that it is safe. The defendant comes running in and drops the fire extinguisher on the ground like this. And then raises his left hand to the gun and points. This is what we see in the video. Him putting the fire extinguisher on the ground and then raising the gun.
Your Honor, I'm going to object. He's facing the wrong direction.
That's an argument.
Okay.
I'd like to actually have, well, I'll leave it alone.
So what you see in that video is his left arm reaching for the gun, holding it up. You can see it again on the video here. His left arm reaching up towards the gun. That is what provokes this entire incident. And one of the things to keep in mind is that when the defendant provokes the incident, he loses the right to self-defense. You cannot claim self-defense against a danger you create.
Right. He created
That's
the
critical
danger,
right here.
so how is he going
If
to claim
you're the
self-defense?
one who is threatening others, you lose the right to claim self-defense.
Exactly. That's like the George Zimmerman
Then we
case.
have the chase that occurs after that. And we have taken that drone video and we have slowed down portions of that chase for you. So what we have right here on the screen, this is Exhibit 84, and this is the middle portion of that incident. And you can see Mr. Rosenbaum chasing after the defendant, throwing that plastic bag, and then the defendant turns and points the gun back at Mr. Rosenbaum. And this is the moment in time when Mr. Rosenbaum essentially does sort of a little hop with both of his hands in the air. And the defendant has testified. He saw at that moment that there was nothing in the defendant's hand, or in Mr. Rosenbaum's hands. He was unarmed. There's the defendant turning and pointing the gun. Mr. Rosenbaum leaps, his hands out to the air, and then watch here at the end. This is where the shooting occurs. Mr. Rosenbaum is not even within arm's reach when the first shot occurs. I'll play that again. The defendant is pointing the gun at Mr. Rosenbaum. Mr. Rosenbaum raises his arms off to the side. The defendant approaches these cars and slows down, and then turns and shoots Mr. Rosenbaum. Finally, I'm going to play you Exhibit 86. This shows you the final part of that, zoomed in and slowed down. Here's the defendant running in between those parked cars, slowing down, and you can see just how close, or rather how far away, Mr. Rosenbaum was when the defendant shot him.
Wow.
You can see from this video that Mr. Rosenbaum is not even within arm's reach of the defendant when the first shot goes off.
Jeez.
The defendant fires 4 shots in quick succession. And I'll come back to this in a moment, but you'll note during this entire sequence, it's the defendant who chooses where to go. He's the one who decides to run where he runs. And he slows down right as he gets to these parked cars. That's what allows Rosenbaum to get closer. We've seen this on the aerial footage from the FBI, and I want you to see that perspective as well.
Man, that That's crazy watching that.
This is Exhibit 25. This is the annotated aerial footage. You see the defendant approach, running in the same direction as Mr. Rosenbaum. This is where the pointing occurs, in the direction of the Zeminskis. You can see Joshua Zeminski's right there on the screen. I'm going to put the cursor over where the Zeminskis are. They're right in there. The defendant is pointing his gun right here, and he's pointing it in the direction of the Zeminskis, because they're standing next to that car. And then the chase occurs. Now what's interesting to me is, watch when the crowd starts to run. The crowd's already starting to run here even before the defendant has fired a shot. That's likely because they heard the first shot from Joshua Zeminski, and the crowd starts to run away. The defendant has testified that that shot from Mr. Zeminski had nothing to do with his decision to kill Joseph Rosenbaum. And I'll come back to that in a second. Finally, I'm going to show you this incident from the perspective of Drew Hernandez, because he is behind all of this, and then he comes upon Mr. Rosenbaum's body. Is that audio playing? Why is the audio not playing? Is it coming? I'm not sure why you're not hearing any audio on that. Is Brian around? He's not. All right. Can you text Brian, please? At any rate, for this purpose, I'm sorry? At this point, the defendant has shot and killed Joseph Rosenbaum, and Mr. Rosenbaum is laying face down. That's where he falls. Richie McGinnis actually rolls him over after trying to stem the bleeding here. You can see in the foreground that plastic bag that Mr. Rosenbaum threw on the ground. I don't think there's any dispute. There was nothing harmful in that bag. It was a clear bag containing some clear items.
Objection. There is a dispute what's in that bag.
Then you can make that dispute in your argument.
Wow.
It's argument, and you'll be allowed to respond.
You hear the defense?
You can see in this video the crowd is attempting to save Mr. Rosenbaum's life.
This is sad right here. When I first saw this, it was hard, very hard to watch.
So, we have shown you the defendant murdering Joseph Rosenbaum from 3 different angles. The drone footage, Drew Hernandez, and also the FBI video. The defendant admitted that during this entire incident, he knew that Joseph Rosenbaum was unarmed. I'm going to come back to this in a little while, but there's this alleged threat that Mr.
Robin?
Rosenbaum made earlier in the evening to kill the defendant.
How you doing?
I will debunk that. That did not happen. It is the one fact in this case the defendant wants you to believe that there's no video of. And in fact, I have the video of the entire incident. I've played it for you, and I'll show it to you again. There's no threat. There's also no evidence that Mr. Rosenbaum ever wanted the defendant's gun. He never said, "I'm going to take your gun." He never said, "I want your gun." There's no indication of that. Dr. Kelly has testified that the first shot that the defendant fired at Joseph Rosenbaum hit the victim in the right pelvis fracturing it. Mr. Rosenbaum was incapacitated at that point. He is, whatever threat he might have posed, it's over. There is no further threat. He is falling to the ground, and the defendant doesn't stop after that first shot. He tracks Mr. Rosenbaum's body all the way down, firing 3 more shots. A second shot, which goes through Mr. Rosenbaum's hand, and then a third and fourth shot, one that grazes the right scalp and one that goes right into Mr. Rosenbaum's back. And that is the kill shot. That is the one that took Mr. Rosenbaum's life.
Wow.
There is no evidence that Mr. Rosenbaum was reaching for the defendant's gun. And after that first shot, there's no way Mr. Rosenbaum could have taken that gun even if he wanted to. He is already falling to the ground. He is helpless. He is vulnerable. And as I said, the kill shot is the one to the back. This is that wound. Dr. Kelly testified that the angle of this shot was from the left shoulder towards the center of the back, and the bullet continued on down towards the right lower back area, tearing through bodily organs and killing Mr. Rosenbaum. Here's a picture of the wound to the hand. There's been a lot of testimony about this wound. This is one in which the evidence suggests that Mr. Rosenbaum's hand was most likely turned in this position, palms outward with his thumb to the ground, when the bullet goes through the area in between his middle finger and his ring finger and penetrates the lower knuckle of the middle finger and the index finger before exiting.
But I am reading all
Dr. Kelly testified there's soot in that area, suggesting that the hand was close to the end of the defendant's barrel of the AR-15 at the time of that shot. The defense wants you to believe it's there because Mr. Rosenbaum is deliberately reaching for the gun. Well, that doesn't make any sense. First of all, this occurs after Mr. Rosenbaum has been shot in the hip and has got a fractured pelvis at that point. He is falling. He is not able to walk. He's probably not even able to control much of his movements at this point. When you're reaching for that gun, this is not the way you're going to do it. This is not going to be effective. I submit to you, ladies and gentlemen, to the extent Mr. Rosenbaum's hand ever got close to the end of the defendant's gun, it was completely inadvertent, not at all intentional. Now, we've heard a lot about the Zeminskis in this case, and I just want to carve them out of this case right now because it's a red herring. It has nothing to do with any of this. There's been some focus on that because I think the defense was hoping they could work this into their self-defense claim and make an argument that that first shot by Joshua Zeminski somehow made the defendant fear for his life. Unfortunately, the defendant wasn't on board with that because in his testimony, he told you that that shot had nothing to do with his thought process. It didn't affect him in any way. He said he didn't think the shot came from Joseph Rosenbaum. He knew Joseph Rosenbaum was unarmed, and he admitted to me, you can't kill Joseph Rosenbaum for something Joshua Zeminski did. So let's just carve Joshua Zeminski out of this case. I'll deal with him on his arson trial in January, but until then, it doesn't factor into any of the decisions the defendant made. And in fact, as you see on the FBI video, the Zeminskis continue walking straight on down the sidewalk. They don't pursue the defendant. They don't threaten the defendant in any way. Now, the defense wants you to think Joseph Rosenbaum was there to attack the defendant. We'll never know what Joseph Rosenbaum was thinking because the defendant killed him. So we're just guessing. But let's assume for a minute, yeah, Joseph Rosenbaum is chasing after the defendant because he wants to do some physical harm to him. He's an unarmed man. This is a bar fight. This is a fist fight. This is a fight that maybe many of you have been involved in. Two people, hand to hand, we're throwing punches, we're pushing, we're shoving, we're whatever. But what you don't do is you don't bring a gun to a fist fight. What the defendant wants you to believe is that because he's the one who brought the gun, he gets to kill. So I want you to contrast this, two different scenarios. One scenario where there's two guys who are throwing punches at one another like a bar fight. I think we'd all agree you can't kill someone. You can't punch the guy, knock him to the ground, and then get on him and strangle the life out of him. That's murder. So what's the difference here? The only difference is the defendant brought a gun. He brought his AR-15. That's why he's got to come up with this cockamamie theory that Joseph Rosenbaum was not only going to take the gun, but take it and then turn it on the defendant. And the defendant actually told you that he thought Joseph Rosenbaum was going to take that gun and not only kill him, but kill other people, which is really ironic considering the defendant is the one who killed people in this case, and the only one. But putting that aside, they have to convince you that Joseph Rosenbaum was going to take that gun and use it on the defendant because they know you can't claim self-defense against an unarmed man like this. You lose the right to self-defense when you're the one who brought the gun, when you're the one creating the danger, when you're the one provoking other people. The defendant fired 4 shots at Joseph Rosenbaum and caused 5 wounds total. The first shot fractured Joseph Rosenbaum's pelvis. This causes him to be helpless. He is falling face first to the ground and he is vulnerable. The second shot went through his left hand, probably ricocheted off the ground and hit his lower left thigh. It's a flesh wound. I'm sure it hurt, but probably not all that serious. The third and fourth shots are as Mr. Rosenbaum has fallen almost completely to the ground. He's parallel to the ground. He is almost face first to the ground.
Because of what he had on
the defendant fires a round into his upper back, which is the kill shot, and another round which grazes his right scalp.
Proud Boys and Boogaloo Boys.
At this point, as you saw in that video, a crowd rushes to that body to try and save Joseph Rosenbaum.
Yeah, I think Kyle
They're trying to put clothing on the wound to stop the bleeding. They're going to take him across the street to a hospital. KMH, Frederick South, is literally right across the street. And this crowd, except for the defendant, are all focused on trying to save this person's life. A person, by the way, they probably had never even met before. Because that's what most people do. Richie McGinnis testified. I rode with Rosenbaum in the back of that SUV. I told him we'd have a beer together when this was all done. Mr. Rosenbaum was unable to respond. The defendant decided to pull the trigger on his AR-15 4 times. That was his decision. And he is responsible for every bullet that comes out of that gun. He doesn't get a pass by pulling the trigger fast. He could have chosen to stop after the first shot, after the second shot, after the third shot.
It's true. He could have stopped.
And assessed whether or not there was still a need to keep firing. But he went 4 times in 0.76 seconds. The defense has made a big point of this, how fast he fired.
Robin Fox,
as if that somehow excuses him.
On Cash App.
Exactly the opposite, ladies and gentlemen. He controls how quickly he pulls the trigger.
Your donations, you
he
guys
is in control
really
of that
can,
decision-making process.
Really helps me to keep my boots on the ground.
No one else made him do that.
Keep getting...
and this is indicative of someone who doesn't care about
gas,
the consequences, doesn't care to stop and figure out, am I good? Do I need to stop? Or I'm just going to keep on going.
All this stuff.
And as I said, he tracks the body all the way to the ground with those second, third, and fourth shots.
If you want to do like Robin Fox and just send a donation
the only
through Cash
way
App,
that you could possibly justify the murder of Joseph Rosenbaum is if you believe that Joseph Rosenbaum was actually reaching for the defendant's gun
and the work behind it,
and that a reasonable person in the defendant's position with that AR-15 strapped tightly to his chest would think that Joseph Rosenbaum was even capable of taking that gun away as he's falling to the ground with a fractured right pelvis.
This stuff is very time consuming.
And then, not only all that, you'd also have to believe that Joseph Rosenbaum was going to turn that gun around and use it to kill the defendant. You have to believe all of those things to justify the murder of Joseph Rosenbaum. That's why the defense is trying so desperately hard to convince you that Joseph Rosenbaum threatened to kill the defendant,
appreciate you as well,
which never
Robin
happened.
Fox, for just
That's why they're
acknowledging
trying
the
so
work
desperately hard
of a live
to convince
stream-
you
live
that Joseph
streaming
Rosenbaum was
and
reaching
what
for
we
that
have
gun.
to, go through to
Because
provide
if he's not reaching
streams.
for that gun,
So
and
anybody
he's not
that
going to use it to kill the defendant,
can
it is not
appreciate that
justified.
kind of work,
There is
I
no
appreciate
valid
you
self-defense
back,
claim.
you know.
One of the things the judge has instructed you is that when the defendant provokes this situation, he has to exhaust all reasonable means to avoid killing someone. Did he?
Leo,
He didn't have to shoot.
You having trouble hearing me?
He's the
Let
one
me know, you
who
guys, if
chose
my
where to
mic
run.
is not picking
He chose
up.
to run in between those parked cars. He slows down as he gets there. The crowd's already running away. You know, the defense wants to make a point. There's a whole bunch of people over there who are doing stuff to cars, and the defendant had no escape route. The crowd's actually already running away at this point. They've heard the first gunshot from Joshua Zeminski, and they're already starting to scatter. But if you look on the video, there's a huge open space in that lot where the defendant could have circled back around, and he actually does circle back around after killing Rosenbaum, where he could have gotten away. He has to exhaust all reasonable means of escape before killing Mr. Rosenbaum. Your Honor, I do have some more video I want to play. I'm having a little bit of technical problems that I'd like to work on, so I think this would be a good time to pause, if that's okay. Okay, thank you.
All right. Please don't talk about the case during the break. Read, watch, or listen to any account. And we will begin again at, is 1:45 too soon?
Did you say 12:45 or 1:45?
Oh, well, I thought we'd have it leisurely. No, how about 12:45? Is that a better idea?
Oh, okay,
do
Leo.
that.
I'll try to see if I can
Please don't
fix
talk
this
about
mic
this.
issue. Thanks for letting me know. It's kind of, oh man, I'm about to drop it. When you're wearing a hoodie, it's kind of hard to place the mic in a good position. So I don't know, I gotta play with it a little bit. How's that? Does that sound better, you guys? Let me know if that sounds better. Testing, 1, 2. Okay, so the court went silent. I believe they went on break, didn't they?
All right.
Let's see.
When we get to the point of reducing the number to 12, we
Thanks for
have to
liking the
decide what to
stream,
do with
Robin.
the
You're
other
killing it. Between
6.
likes and donating,
And
you're
the
supporting the
alternatives would
stream.
be
I
to
like
just
that.
let
I like
them
when people help
go
support
about
the
their
stream.
regular business.
So if you guys can all go ahead and share it, like it, share it to
and
your
tell them we
group,
might
share it to your
call them
page, you
if we need
guys.
them. Or we
Don't
could
be
keep
afraid
them
to
here,
send stars on Facebook.
where
Don't be
they
afraid to
can
donate
sit
on
and
Cash
watch
App, you
daytime
guys.
TV.
Let's,
I don't know. They have to, obviously, they're limited
us
channels
streamers
they can
love
watch.
it when you guys support us. We love that. Thanks, Leo, for letting me know my audio's better. Appreciate it.
And of course, they will not be permitted to talk about the case. So, any preferences?
My preference is to keep them here.
Yes, okay, we'll do that then. And we'll have to find some way to entertain them. That make sure it doesn't involve some of the channels that are available on the television.
My stream
Okay.
seems to keep going in and out on YouTube. I don't know what that's about.
12:45.
All right, looks like the stream popped back up on YouTube now. It's strange. First it says that it was taken down for violations, and then it pops back up again. So I don't know what's going on with YouTube. But If you guys are on YouTube watching, come over to Facebook. We got a pretty good stream going on Facebook here. You can find me on Raw Topic on Facebook. So let's see. So who all we got right now? Who? Drop your city and state, you guys. Let me know what platform you're watching from. LinkedIn, Twitter, Twitch. I'm on YouTube. I'm on Facebook today. So I'm doing quite a bit of different platforms. Bear with me, you guys. I'm just looking at, just checking out my streams on the different platforms and making sure everything's all good. Oh, the court ended their stream. Okay. I thought it was my stream that ended for a minute. I had to be like, what? What is going on? All right, you guys. Do you guys? I got some video I want to play. After Jacob Blake, after the shooting of Jacob Blake, this is what kind of triggered this whole scenario of events. I went out and filmed after the officer that shot Jacob Blake. The verdict came back that he will not be charged. So I had to go down to Kenosha to film that. And I want to show you guys the footage from that night. So let me see if I can cue that up real quick until the trial comes back. And of course, you guys, we can still talk about whatever. I'll put the comments up. Let's see if I can.
Oh, man, okay. I don't know what happened.
Okay, let's see.
Oh, man, okay. I don't know what happened, you guys. I lost you. I think I got caught up in some bad area.
I'm gonna call you back because I'm excuse me.
What's up, you guys? I'm in Kenosha after the Jacob Blake verdict. The officer will not be charged. People are agitated. We got marches going on and arrests going on right now.
So you guys, this is footage of me in Kenosha right after the Jacob Blake decision that the cop Chesky would not be charged for the shooting of Jacob Blake.
Get your brothers upset. Everybody's mad. Everybody's tensions are high. Over the tensions
Tensions are high right now in Kenosha. National Guard is out here. People are pissed and agitated right now. I was trying to catch up with the march, and I decided I'll stop and film this just in case this needed to be documented. You guys type the command !notify in the comment box so you can be notified immediately the next time I go live.
So Leo's saying, why the judge dismissed a gun charge on Kyle? I didn't know he did that. When did this happen? When did he dismiss the gun charge? Anybody know anything about that? Let me know.
You guys drop your city and state in the comment section. Let me know if you guys are from Wisconsin. Are you from Kenosha, Racine? Let me know what city you guys are repping right now.
Hey, what's your page?
Raw Topic on Facebook?
Raw Topic on Facebook?
Yep.
All right, bet. I got you.
Thank you. Appreciate you.
No problem. Raw Topic on Facebook.
What's up, Jose? What's up? Red Wing, Minnesota in the house. We got Dallas in the house. Nikki, what's up? Ashley, how you doing? No, it's definitely not warm. It is cold out today.
So Leo, you heard that on Daily Wire?
You guys go ahead and type I notify in the comment section so you'll be notified immediately the next time I go live.
Okay, I didn't know anything about that, but that's kind of strange that he would dismiss the gun charge. I mean, that's one of the. I mean, he obviously shot 3 people, so I don't know how that even
Looks
works.
like the police, they're gone. I think they took the one guy. He was screaming, "Fuck the police," and he was pissed, so they stopped and basically arrested him. I think they let his friends go. But I thought I would stop just to document everything that was happening because I thought it was about to go down because everybody's on high alert today. Yeah, I'm safe out here as of right now. I'm about to try to catch up with the march. Heather Thomas, how you doing? You guys drop in the comment section what your thoughts are about the verdict. Do you guys feel like it was right? What do you guys think about the fact that that officer wasn't charged for shooting Jacob Blake 7 times with his kids in the car? What are your thoughts? Do you think that was justified? Please share, you guys. Share your thoughts. Share the stream. I have no idea what a march is. So I'm gonna try to catch up with them. I'm in Kenosha right now. The city is on high alert. National Guard is out here. The businesses are boarded up. People are agitated and pissed off. I want to know, you guys, I want to have the conversation. What are we going to, when is it going to stop? These officers are never charged. They're never accountable for the actions, the brutality. Was it necessary to shoot 7 times in the back? I don't think so. I want to know what you guys, what your thoughts are. Because we got the George Floyd. That case will be coming up soon. And I know we all want to see those cops charged.
You can tell this video is...
The Kyle Rittenhouse case is going to be coming up soon. We want to see him charged.
So we all know what happened with George Floyd trial.
I'm trying to figure out if anybody know where the march is. Let me know.
All right, Leo, I'll check.
Because I cannot find anybody.
See.
I walked away for a couple minutes and they have marched. I don't know where they went. You guys go ahead and share the stream out. If you want to know how long you guys been following Raw Topic,
you can't handle the truth.
Use the command, exclamation mark.
Blake was shot outside the car,
followage.
so no. I think case was handled correctly.
And that will tell you how long
and
you've
this
been
is
a
coming
follower.
from someone who
You can also use the
at
command,
one point was
exclamation
arrested in
mark,
front of his
commands
child. It happens.
with an S. And that
Y'all
will give
gotta
you all
stay
the
cool.
commands you can use in this live stream.
Or you gotta say cool.
Man, those guys march fast.
Well, I don't feel like the cop had to shoot him 7 times in the back of all places. And I just think it was reckless because his kids were sitting in the car.
Let me know in the
to
comment section
shoot
if
inside
you
of a
guys
car with kids in the back seat 7 times in the
seen
back.
the press
To me,
conference
that's
today.
just that's too much.
It was about almost
that was
2 hour
very
long
reckless,
press conference.
and I think that could have been handled better.
What's up, Nikki? What's up, Latrell? Ashley? Somebody said they're watching Corey Elijah. Do you happen to know, is he following the march? And if so, where the hell is everybody? I have no clue. I'm gonna have to. Columbus Park. I don't even know where the hell that is. I'm not from Kenosha. So I'm just gonna see if I can hear some chanting or something.
We need to stop rushing to conclusions. It's ripping us apart and turning
I
us
literally
against
walked
one
away
another. And I wish that the
for like
kids
5
weren't
minutes.
there. But going at the cops like that,
they
is
marched
just
right
asking
out of
for a
here.
bullet.
Keep straight on 21st
Yeah, but
Avenue.
7 bullets.
Let's see, what street am I on
to
right
the
now?
back though.
I'm coming up on.
I mean, I don't know. I think it was a little excessive.
I'm gonna need you guys that are watching to guide me in the right direction of the march. 'Cause I don't know where the hell I'm at. 53rd Street.
No, this was.
We got pickup trucks acting
this was
stupid,
filmed
so
a couple months back
you know who that is.
During the Jacob Blake
What street is that? 21st Ave.
Back when
all right, so you said keep straight on 21st Ave.
they decided not
all
to
right,
charge
so I'm
the
on the
officer
corner
that
of
shot Jacob
21st and
Blake. So this is
53rd.
quite a bit.
So I can keep straight
quite
this
a couple
way, right?
months old, you guys.
Keep going south. Oh crap! Here you go with the south. Y'all telling the wrong person. South, north, east, west. I don't know that. Yeah, I get confused with all that.
This is a.
I hate when I try to ask for directions and they
in this
get
part
to
of the
talking
video,
at east, south, north. I'm like, what the hell?
I was on a protest march
I am
and
bad with
somehow
I sense
I
the
lost
direction.
them. I couldn't find them. So
you see them?
People
Where do you
watching the
see them
stream
at,
was helping me get back to the march.
Where are they at? Right now, I'm in the corner of a Spoon Sushi Cafe. So I hope I'm going the right way. I don't know. I'm gonna need y'all to help me out here. I was trying to help out the guys that got pulled over and make sure I filmed it because there's a shitload of cops and it looked like it was gonna be a bad situation. So I wanted to film it and then I lost my march. All right, let's see, where the hell am I? 21st Street. I don't know, I'm coming up on a Catholic school, looks like. You guys, I'm lost as hell. Go left. When do I go left? Am I going the right way? I'm going towards this church. What's up, Sarah Ann, by the way? How you doing? Does anybody know where they're marching to? Oh, that's Columbus Park where the church is? It don't look like a park. It looked like a church, a school, or something.
He actually did not die. He is a paraplegic, so he's paralyzed now. So luckily he did make it.
Keep going, take that to 14th
live another day. So he is not dead.
Man,
and
I'm on 20 Ave.
But we still
That's
would
a
like to
couple blocks.
see justice for the cop.
Y'all trying to make me get a workout in.
We'd like to see the cop at least
Then
get
go
charged with
left
something for the 7 shots
to the Boys and
back.
Girls Club.
I mean, I just feel like that's reckless.
Don't try that. So, talk to me, guys. What are your thoughts about tonight? I mean, if you're not going to charge the cop, at least fire the cop. I mean, I just don't feel like this cop should be a cop. He seemed scared. He seemed reckless. All right, what you got to say? You have to run right there until you reach. You said run. 14th Avenue and then turn left and 52nd on the right. Man, I am not running. Check it out. I got on my Jordans, my Sky Jordans. Okay? I ain't gonna get messed them up. Are y'all out of y'all mind? Popo left and right. Looking at me crazy.
Man, this night brings
I wore the wrong shoes for this.
brings back a lot.
See, I didn't know they was
memories.
gonna march. That's the thing. I thought the march was
pretty
yesterday.
fresh back at. This is what started like this whole thing was the Jacob Blake shooting.
Let me see if I can get on the sidewalk. I'm all in the street because there's snow all over the place. I ain't trying to bust my ass on this ice. Do you guys know, are they still marching? Did they stop? Give me an update.
I got so lost, so turned around, and I didn't know where nobody was at. I'm just trying to find everybody.
What did it say? I hope there is a peace in Kenosha. What's up, Karen? How you doing? Thanks for the positive words, you guys. We can use all the positive energy right now.
Independent sources are best, and maybe the cop needs to be up for reevaluation. The cops are human just like we are.
How many more blocks I
Regardless
got?
of training, people get scared.
See, when you're not marching with a group of people, it's like,
yeah, that's you
putting
a lot
in work.
Of valid stuff you said.
I feel like this is like a hike.
These cops should get reevaluated more often.
See how a group of people can motivate the whole
And
situation?
they are human, but sometimes they act like, they're inhuman. So I don't know.
So we got I don't know if you guys have been following the streams today. We had a couple streamers. I know a couple guys were streaming different things. Militia was here today. Militia might still be here. So they were here to, they always come around when Kyle Rittenhouse got court.
So lost. I don't
They
know
always
how
like
I
to
got
come to the
that behind.
courthouse.
You know what happened is I was filming those cops. I saw those cops.
And then of course we had the
arresting people.
The press conference.
So I wanted to film it
with the
and
DA.
just make sure nothing crazy was gonna happen.
So it's been
so I guess that's how
it's been a crazy day.
Behind.
Channel 2 News. I just almost bust my ass. All right, you guys, where am I at?
That's right.
Let me see. 54th Street. Man. How the hell did they march so damn fast? What's up, Monica? Milwaukee in the house.
God, I am tired, man.
Meal ticket, okay.
I was up all last night. And this judge, man.
I wish I could say your name.
He dragged out the first
Maraji Kwanzaa?
2 hours of this court.
I can't even say that. I like the name, but I can't say it. I don't want to butcher it, but welcome to the stream, Ingrid. What's up, Ingrid Moreland? How you doing?
Right,
yeah, it's cold out here. It's freezing. Somebody give me an update. Where's the marchers at? April, what's up? How you doing? Where the hell is the marchers at? I'm confused. Popo down here. I don't know what they're doing. But I wonder if there's something going on down here. This Zoom is amazing. Somebody said make a left. So make a left at the corner of 14th and 54th. So I gotta go straight this way? Let me see what the... Go towards the police. Okay, got you. This is like an interactive game right now.
So
appreciate y'all helping me. Something might be going on, but where these cops is at, I think I see a crowd. I don't know. I'm gonna try to be safe. I appreciate you guys, everybody concerned about my safety. I come out here to get the footage for you guys. I know a lot of y'all don't like being out here, but this excites me. This is where I get my rush, is coming out within the chaos. So I figure I'll do it for you guys. As long as ain't nobody purging, I'm good. All right, hold on. Let me regroup everything here. Yes, the People Revolution is there marching for the last. The People Revolution is in Kenosha. They here. They've been doing it big. So do I keep going straight, you guys? Right now I'm on the corner of 53rd and 14th. All right, I think I got it, you guys. I think I got it. Man, you guys, y'all saved my ass on this one. I would not have made it had y'all not have helped me. So I appreciate y'all. I would have still been walking. But it might be over. It look like people walking to their cars now. You guys, once again, if you're not already being notified when I go live, !notify in the comment section, you guys, and that will notify you the next time I go live. So I just caught up with the group. I haven't seen Kenosha this lit since the second day of the Jacob Blake. Looks like we got a lot of, I don't know if we holding up traffic or is that a caravan of cars? Hey, you guys know where they're marching to next, or what the plan is? Oh, they're gonna do a caravan?
They're gonna turn every car around in the Boys and Girls Club.
Okay.
And eventually go back south.
So they're gonna basically march back now?
Yeah, right back into the neighborhood is what they told us.
Make a left.
Oh yeah? Okay. Thank you. Appreciate that, you guys.
So that might be a process, turning everybody around in here.
Yeah. Do you know these cars part of the caravan then? All these cars?
Yeah.
Oh wow, that's a lot. Okay. So apparently all these cars are part of the caravan. That's a lot of cars.
You guys are just joining the stream.
So it looks like they're trying to turn the cars around to go back.
Turn it down a little bit. If you guys are just joining the stream,
! Notify. That will notify you.
We are
next
waiting
time I
for
go
the
live.
court to come back.
Put that in the comment
if
section.
I can even
that
make
is
it that
command
long, I'm about
you can
to fall
use.
asleep. But
you use !
We're
Commands.
waiting on the court to come off
You'll
recess.
See a whole list of commands that
and
you
in the
can
meantime,
use on
I'm
the
watching video that I took in Kenosha. This was the day that they came back with a verdict that the officer would not be charged for the shooting of Jacob Blake. So everyone went out
So
there
it looks
to
like
protest.
everybody is organizing right now.
It was quite the protest, I must say.
Yeah, you guys, that's a good idea. Ingrid, click on the bell and click all so you get all my notifications when I go live, when I make a post. You'll get all that. Because if you're just following me and you're not clicking the bell, then you're not going to be alerted when I go live. So there's Portia. She was on Time Magazine. Hey, Portia, I saw you on Time Magazine.
Thank you.
Congratulations. You deserve that. That's Portia. She is a huge activist. She quit her job to pursue the movement, and then she was on Time Magazine just last month. Hey, Portia, what's your last name?
Bennett Bay.
So they can find you, Portia Bennett Bay, on Facebook? So check her out, you guys. Portia Bennett Bay. She had a huge article in Time Magazine. She was recognized for like top 10 activists. That was a huge achievement from somebody in Kenosha, especially her, because she quit her job and she risked everything to fight what she believed in. The next thing you know, they recognized her in Time Magazine. So I thought that was amazing. That was just so motivational, inspiring for anybody who wanted to give up something that they knew that they didn't really want to do for something that they want, that they love and believe in, and it paid off for her. She was recognized by Time Magazine, so that's amazing.
Yes.
So it looks like everybody's trying to get the cars and everything in order. Let me see if I can kind of get in the mix of what's happening here without busting my ass.
Are you ready? Marcus, are you ready?
Hey, thanks for leaving me, Dick.
Hey, Dick.
Hey, it went
Dick.
it went down back there. I had to stop. The fucking cops pulled these stopped these guys because they said fuck the police. Fucking swarm of cops came in. I thought it was about to go down, so I stopped and filmed it.
Say his name.
No, just some random guys that were driving. Yeah, they were roughing them up.
They got pulled over for fuck the police.
Yep, they got pulled over, dragged them out the car and whatnot.
For fuck the police, huh?
Yep.
Wow, that sounds...
So I had to stop and film that.
No peace. No more racist ass.
Oh, you get harassed by the police for saying fuck them.
Well, you know, the police were like, oh, you know, everything's on high tension today. You guys, we got Kevin, Never Stop Media. Y'all know Kevin. Y'all know Kevin. He's on YouTube right now doing his thing.
Those are all militia guys?
Oh, yeah.
Oh.
Oh, yeah.
You should ask them their names.
I filmed a bunch of them earlier.
Invite them to tea and crumpets. God bless America!
I don't know if you guys heard before, but TPR is representing. They are marching as well. The People's Revolution in Milwaukee, they are helping out the cause. They've been marching for over 200 days. And they are in Kenosha to support. Let me get my phone right here. Sorry about that, you guys. I'm trying to.
Hey, why are we stopping? Let's keep this moving, baby. What we doing? Let's go. What's going on?
No problem.
Jacob Blake! Jacob Blake! Jacob Blake! Stay in there! Stay in there! Jacob Blake! Jacob Blake! No peace! No peace! No peace! No, police! Keep moving now! No peace! If you turn, you should be in the front with peace! Silence! Don't be trying to do everything! Let's go! Jacob Blake! Jacob Blake!
They want a part two? They want to call Rittenhouse part two or what? I go fucking ask them. I already asked them. I said, what the fuck you guys here for? What are you doing? Oh, a bunch of things.
So you guys, people are marching today. They are not happy with the verdict. TPR joined in on this. They want justice for Jacob Blake. They want the officer charged. They want the officer fired, convicted. They're not happy with that verdict.
I said, what are you guys here to protect some more businesses?
We got the National Guard. Those ain't actually kids. Those are teenagers that are just look like kids. They're little.
Hey, stop that! We're gonna stop right here for a second. Let everybody collect. This group has to stay together though. No more.
Tell Corey Elijah the protesters on 21st Street. Hold on, I'm coming up to another street. Let me look. I was lost just a minute ago, you guys. So
it doesn't work that way.
You guys try to help Corey out.
Most black folks understand this because white people don't even care about themselves. Wow, okay. But you are entitled to that. What's wrong with my mic now, Leo? Is it out?
Hey, tell Corey we're on the corner of 50th Street and 14th Avenue.
Alright, I'll try and fix it. Oh, I sound out.
out there, city. Come on, wake up.
We are going back over
Testing. 1, 2, testing. Do I sound okay now? Testing. 1, 2.
We're in the corner, 14th and 50th.
Yeah, but Leo, I got the mic in my hand. Look. This is the mic right here. So it's not even on my hoodie right now. And I still sound bad, you're saying?
Guys, go ahead and share this out. Don't forget to follow our topic. Democracy looks like. This is what democracy sounds like.
What do we want? What do we want?
It's cold out. Y'all best believe it's cold out tonight. Disturbing the neighborhood right now. This is what you call no justice, no peace. You wake up the neighborhood. If there's no justice, there's no peace. This is when you make noise. This is definitely a peaceful protest. There's nothing violent about this protest. This is not a protest of destruction. This is a protest to just make noise and to be heard. This is very peaceful. Everybody is being responsible, caravanning, protecting each other. Share this out, you guys. Share, comment and follow our topic. Like it, love it. I got you guys. I'm gonna keep filming as long as they're marching. So I got y'all covered. We're in Kenosha, you guys. For you guys that are just joining the stream, this is a march in Kenosha. due to the verdict that there will be no charges for the officer of the shooting of Jacob Blake.
No! Justice! No! Justice! No! Shut it down! 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 Black Lives Matter! 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 No peace! No justice! No peace! No justice! No peace! No more racist! Police! No justice! No peace! No justice! No peace! No justice! No peace! No more racist! Police! We ready! We ready! We ready for change! Come on now, y'all! We ready! We ready! We ready for change! 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 Ready! We ready! We ready! We ready for change! We ready! We ready! We ready for change! We ready! We ready for
What's that?
He's out there.
I did?
Yeah.
Thanks, man.
For change! We ready!
You guys let me know if you still hear me. I think my mic battery might be dying. So if it starts getting weird on me, let me know. I'm gonna have to disconnect the microphone from my phone. So let me know if the audio is still clear.
Black Lives Matter! After the
All right, all right. They're still not back from recess. I'm gonna take a break, you guys, and go get something to eat and use the bathroom, all that good stuff. So I'm gonna log off and come back, I guess, when they come back.
So stay tuned. If you're not following, make sure your notifications are on. That way you know the next time I go live. If you're on Facebook, use the command !notify, and you'll be notified when I go live. So I'm going to go and get something to eat and use the bathroom and take a little break, you guys. Appreciate you guys coming through, and stay tuned for the next one. And remember, if you can't come real, at least come raw, you guys. Raw topic.
Perfect.